hit subscribe. Subscribe to my guy, Uncle D. Tell him Big Bad sent you.
Spurling. I'm an attorney here in Houston, Texas, an advocate for black men, largely because I am a black man. I'm a black father. I have black sons. Hey, man, I do what I do.
What's up, everybody? Welcome to the broadcast. This is Dennis Spurling, also known as the Blizzard King. Big shout out to everybody in the chat room. Make sure you like, share, and subscribe. I want to welcome all the new folks in here. Welcome. I know you all have been seeing the numerous conversations discussing this dream team that Karmelo Anthony's family has put together for him in the form of these dynamic lawyers. Shout out to all of them. And, I wanted to give you the truth about Karmelo Anthony's chances of freedom on appeal. Now, on Tuesday, June 9th, 2026, and Karmelo Anthony was convicted of murder in Collin County, Texas. And he was sentenced to 35 years in prison. And his this has divided the country because the victim, Austin Metcalf, was a young white boy. And as you know, Karmelo Anthony is a young black boy. And he's also 17. And as I've told you all before, racism is the national sport here in the United States. Shout out to all the people all the Europeans who are enjoying our fast food. I know you all are enjoying your quote unquote football matches, i.e. soccer. I get that. But the national pastime here in the United States is not baseball. It is racism. And all groups participate in it, even if you don't have racism in your country per se. When you get to the United States, you will side up with your own team. That's pretty much how it works here. It's not going anywhere. So anytime we have a racial issue, we're gonna talk about it. You have people talk about a case involving a football player from way back in the 60s named O.J. Simpson, and people are still talking about it like it was the 1995 Super Bowl. They just will not let it go. This is where we are in America. So you can imagine with this fresh fuel to the racial fire that is going to be talked about. Now, again, as I said, Karmelo Anthony was convicted of 35 years. A lot of black people saying, hey, that's too much. Some are saying that's too little. Okay. So, yes, this case isn't over, but, because they filed an appeal. His lawyers filed a notice of appeal the next day. And so, we need to be clear. The trial is over. And once the case leaves the trial court, it goes to the 5th Court of Appeals in Dallas. Okay, this is a state court of appeals, and the rules change completely. This is part a lot of people don't understand. An appeal isn't a second trial. Let's be clear about that. The appellate court isn't going to bring in new witnesses. It's not going to replay the case from scratch. It's not going to say, well, social media, didn't like the verdict, so, let's try it again. That's not how appeals work, okay? And the 5th Court of Appeals is going to review the record, and that record is going to include the clerk of court's record, the court reporter's record, the voir dire transcript, the jury charges, the objections, the rulings, the admitted evidence, exhibits, the punishment evidence, and the final judgment. That's it. They don't care what anybody on YouTube has to say. None of your Facebook posts matter, all right? The only battlefield is those things I mentioned, and that creates a serious problem for this appeal. A lot of people are making a big deal about the fact that Karmelo Anthony has a new group of lawyers. Somebody type dream team in the chat room, right? And let me be clear, I'm not taking anything away from these lawyers. I wish them the best. Some of them have some real experience and reputations, okay? But a new legal team doesn't erase the facts of this case. A new legal team doesn't make that dead body go away, the knife, the witnesses, and the confession. That's the problem, okay? And this isn't one of those cases where the state barely had evidence. Okay, this is one of those cases where the identity of the killer is unknown. Okay, it's not a case where the murder weapon can't be found. This is not a case where there were no eyewitnesses. This isn't one of the cases where the medical evidence is confuting. In this case, the state had a dead body, a murder weapon, dozens of witnesses, video evidence, body cam footage, and the state had Karmelo's own statement admitted that he stabbed Austin. That's a mountain of evidence. And so when people say he has a dream team now, my response is simple. That's good. That's great, but this isn't a movie. Great lawyers still have to deal with the record, and the record is ugly. And the jury already heard the case once and convicted this young man of murder, and they didn't buy self-defense. They didn't compromise with manslaughter. They gave that young man 35 years, so y'all need to stop acting like new lawyers automatically mean freedom. The appellate court isn't going to say, well, Karmelo has better lawyers now, so let's just throw out that old conviction and try again. So I don't want you all to get hypnotized by this phrase dream team. A dream team still needs a legal issue strong enough to overcome a verdict. And if this case gets reversed and goes back for a new trial, the state will still be standing there with the same core facts: a dead 17-year-old child, a knife, a chest wound, a medical examiner, young witnesses who will still be alive to testify, video evidence, and Karmelo's own words. That's the cold hard truth. That is the cold hard truth. And some people are going to hear this and say, oh, you're just against Karmelo. You're a sellout. We need real lawyers. We need Johnny Cochran. Johnny wasn't a sellout. Let me stop you all right there. I was fortunate enough to meet Johnny Cochran at the atrium of the Southern University Law Center in Baton Rouge right now. The same law center right now, somebody type right now, the same law center where my photograph now hangs in that university's Hall of Fame, right there in that atrium where I met Johnny Cochran. My photograph now hangs in that hall. So I know exactly who Johnny Cochran is, and all of y'all, they know exactly who I am. Somebody type right now. You understand? I know what Johnny Cochran represented. I know I'm not taking anything away from the brother. But here's the thing. Johnny Cochran is dead. He died in 2005. He can't help Karmelo Anthony. He can't walk into the Fifth Court of Appeals. He can't file a brief. He can't argue Batson. He can't fix a bad trial transcript. He can't undo missed objections. He can't cross-examine witnesses. He can't make a dead body disappear. He can't make a murder weapon disappear. He can't make a medical examiner disappear. He can't make dozens of witnesses untestify to what they testified to. And he can't turn a weak appellate issue into a strong one just because people online are emotional. That is the hard facts. And I'm not saying that to disrespect Johnny Cochran. He's one of the greatest trial lawyers of our time. But Johnny understood facts. He understood law. He understood evidence. He understood juries, and he understood strategy. And most importantly, he understood the record. And he didn't win cases by selling a fantasy. He won cases by finding weaknesses in the state's case and attacking those weaknesses with skill, preparation, and precision. So when people say we need Johnny Cochran, what they're really saying is they want somebody to make them feel. Somebody type feel. They want somebody to make them feel like this is going to be an easy win. Somebody type feel. Somebody type feelings. This is not an easy win. And even if Johnny Cochran were alive, he would still have to deal with the same problem every lawyer has to deal with: the facts, the law, and the record. So stop using dead legends to avoid living facts. And while we're telling the truth, let's tell the whole truth. Have y'all read Johnny Cochran's book? Huh? Number one, Johnny didn't become he didn't tell black people fairy tales. He understood the system because he worked inside the system. Did you all know that Johnny Cochran was a prosecutor? He was a deputy city attorney in Los Angeles. Do you know what that means? That means he put thousands of black men in jail, in prison. Does that make him a sellout? He learned how prosecutors think. He learned how police reports are used. He learned how witnesses get prepared. He learned where the pressure points are. Johnny Cochran got a white baby mama. Did y'all know that? It's in his book. Does that make him a sellout? I'm just asking questions. See, that shouldn't take away from the fact that he was one of the best criminal defense lawyers and former prosecutors. Those are two separate things. Had nothing to do with who he decided to date, impregnate, etc. I see what y'all did to that brother Sean Kent over there who defended Rick Child. Y'all searched him all up on the internet. Just because he got a woman that don't look like she's a foundational black American, a black, but he's a sellout. That man is an excellent lawyer. He had a hell of a job. Y'all love to dig up black people and compare them to modern day black people. I'm talking to the black people. White people, step aside. Asians, step aside. Latinos, step aside. This is a black on black conversation. Y'all love to dig up dead black people and compare them to modern day black people. I'm just saying, it's the truth. I'm sitting here as a Hall of Fame attorney inducted into the Southern University Law Center Hall of Fame. And I'm explaining to you all some basic legalese, and you all swear up and down I done sold you out because I'm reading straight up of what's in the book. That's just crazy as hell to me. That's crazy. That's why they tell me not to talk to y'all. That's why my friends and my comrades and my associates tell me, Dennis, why do you even talk to the public? All they're going to do is not like you. All you're going to do is lose business. That's what they tell me. And I say, I'm going to do it anyway. Nevertheless, that experience made a defense lawyer, that makes defense lawyers more dangerous when they deal with become prosecutors, whether you're a public defender or a prosecutor. So don't bring up Johnny Cochran like he was winning cases by lying to black people and selling false hope. He wasn't. He was winning cases because he knew the law, he knew the facts, he knew the record, he knew the jury, he knew how to attack the state's case. That's the difference. And that's exactly what I'm trying to explain to you all what's happening. I'm not telling you what you want to hear. I'm telling you what the law is. I'm telling you what the Fifth Circuit Court of Appeals is going to do. I'm telling you why legal sufficiency is hard. I'm telling you why Batson is hard. I'm telling you why the jury charge errors depends on the record. This is the truth. And since when does telling you the truth about the legal process make somebody a sellout? I'm just saying. I'm qualified to teach law school. I have an LLM, which is a legal law master's degree. That's more than most of the lawyers you ever met. See, the truth doesn't become betrayal just because it hurts your feelings. Legal analysis doesn't become anti-black just because it doesn't give you the answer you wanted. And a lawyer is not boule, a sellout, or against his people just because he refuses to lie to black people for applause. If you want somebody to lie to you, it's plenty of people on the internet that have pimped themselves out for that. I'm not going to do it. I don't like you all that much to lie to you and spare your feelings. Don't you like having the fact that you have a lawyer who won't lie to you, who will tell you the cold, hard truth? Don't you like, isn't that refreshing? Somebody type refreshing in the chat room. Isn't that refreshing? Wouldn't you like to have mechanics and used car salesmen that won't lie to you and real estate agents? I'm telling you the truth, and you all are mad at me for that. If you all want somebody to tell you that Karmelo Anthony is about to walk free just because that sounds good, y'all need to go somewhere else. But if you want the truth, this is what it sounds like. That's it. Now, I'm going to take a point of personal privilege. Somebody type personal injury lawyer. As many of you all know, I am a civil litigation attorney. I'm a personal injury lawyer. I've been practicing law for 26 years. I'm licensed in 6 different states. Not 1, not 2, 6. I'm admitted to practice law in the United States Supreme Court of America. I'm admitted to practice law in the 5th Circuit, United States 5th Circuit of America, Appellate Court. I took the bar examination 1 time. I scored a perfect score on the Louisiana bar examination. Handwritten, took 3 days, 8 hours a day. I have a bachelor's degree in biology from Grambling State University. I have a degree at Southern University, a law degree from the Southern University Law Center, a JD. Graduate 33 in my class. I have an LLM from Tulane in environmental and energy related law. Takes some people 3 years, took me 1 year. I took every class they offered, got finished in 1 year. My original plan was to be an environmental lawyer. I wanted to work for the EPA. I wanted to save the ducks and pigeons. I wanted to work for the government. But that's not what happened. I end up doing what I'm doing. And I'm not the first one in my family. I never wanted to practice criminal law. And a lot of it comes from the fact that I watched my father, Dennis F. Spurling. So I'm technically Dennis Spurling II. You all have met my son, my older son. He's technically Dennis Spurling III. My father practiced criminal law and family law in Houston for decades. He was licensed in California and Houston. He passed away in 2021. He also taught trial advocacy over at Thurgood Marshall School of Law. Many of the young lawyers that you see around here in Houston, Texas, many of them, not just young, but 40, they passed through his class. He taught trial advocacy. And I live with this man. You understand? So when I talk about trial lawyers and criminal defense courtrooms and juries and the pressure of representing people whose freedom is on the line, I'm not talking from the outside looking in. I grew up in this. I watched my father grind year after year. I watched him go to court. I watched him deal with clients. I watched him carry the weight of people's freedom, families, problems on his back. He was an excellent lawyer. People still talk about his reputation. I go in courtrooms right now. Oh, you're Dennis Spurling's son. But unfortunately, he was one of those lawyers who was basically died at his desk. Before him, there were other lawyers like Mr. Whitcliffe, one of the original black lawyers over in Third Ward where my dad shared office space. See, back then, black lawyers weren't allowed. They weren't welcome downtown in Houston. So they had to get a house office over in Third Ward or Fifth Ward or one of the black neighborhoods. I remember going in and out of places like that as a child. I saw those black lawyers practicing criminal law and family law for years. Somebody type black lawyer in the chat room. Texas Southern University has one of the best law schools in America, right here in Houston, Texas. So we have a lot of excellent black lawyers. They're doing hard work. They're doing necessary work. They're doing respected work, but never really getting ahead financially. And that's the part of, and that's part of the truth people don't like to talk about. A lot of black lawyers were locked out of the highest grossing parts of the practice of law. Number one, being personal injury. Somebody type personal injury. Somebody type personal injury. Somebody type personal injury. Personal injury is one of the most lucrative areas of legal practice. And it's always been an old boy network. That's where the real money is. And black lawyers were not exactly invited into that club. Fortunately for me, because of my education and my work ethic and my tenacity, I was able to get my foot in the door at a very small personal injury law firm in New Orleans after I did a 1-year clerkship in Lake Charles, Louisiana, after I got an LLM from Tulane. That's why I started mastering my craft. And let me tell you something. Real personal injury practice isn't easy. People think it's simple because they see commercials and settlements. When I go into some of these courtrooms, I'm the only black lawyer there who practices personal injury. Most black lawyers do criminal, they do family law. They might do a little personal injury here and there. They don't do what I do because it takes a lot of money up front. It requires a lot of paperwork pushing and a lot of overhead. People think it's simple because they see the commercials and the settlements, but it isn't. You have to master medicine, insurance, evidence, procedure, liens, expert, biomechanics, billing, damages, causation, trial strategy, and negotiation. They don't teach that in law schools. You have to learn that in the trenches. And you're very rarely going to find a black lawyer like myself who practices 100% personal injury law. And that should tell you something about the level of confidence I have in what I do and the path I choose. But even though I don't practice criminal law, I don't confuse that with me not understanding it. I grew up around it. I watched my father live it. I saw crime scene photos on the kitchen table. I was probably too young to see. I overheard conversations year after year with clients. I filed documents in his office. I served subpoenas. I saw how criminal defendants think. I saw how family members act when somebody's facing prison. I saw how hard lawyers work on cases where the public only sees the verdict. And one thing my daddy told me, always stuck with me, he said, criminal law is a no-win situation for the lawyer. If you do a good job and you get your client acquitted, the client may walk away saying, I was innocent anyway. I didn't even need a lawyer. But if you lose, the client gets convicted and they still say, you a bad lawyer. I didn't need you to lose. I could have lost by myself. And that's why one of the first lessons that criminal lawyers learn is they get their money before the trial. They get paid up front. Get your full fee before the trial date, because once the case is over, if the client doesn't like the result, they may never pay. My case is different. I practice personal injury. I only eat what I kill. So if I lose, then I don't get paid. And that's why I have a winning record. But again, I watched my father deal with that. I watched him barter. I remember one year he traded his legal services for a Camaro, like a 1986 Camaro. I'm like, where's the money? Right? I watch him represent people for cars and promises and payment plans. I saw the stress of trying to collect money from regular people who are already under pressure and decided early that they didn't want that. They didn't want that life. I didn't want that. I didn't want to chase clients for money. I didn't want to fight with people about fees after carrying all their problems for years and dealing with it and then having to go to court and operate at the highest level possible and still might not get paid. I wanted my money to come in settlement checks and structured fee agreements. And that's one reason I chose to practice personal injury or civil litigation. So when I talk about criminal cases, I'm not talking as a prosecutor. And I certainly am not talking as a criminal defense lawyer. I know the life they lead. I'm talking to somebody who understands the system, has been around it my whole life, and has no reason to lie to you. And that's the point. I'm not here to waste your time. I'm not here to make you feel better. I'm not here to tell you what you want to hear. I'm not going to pretend an appeal is strong if the record is weak. And I'm not going to pretend self-defense works just because people online are emotional and calling names. I'm not going to pretend a conviction gets reversed just because people are mad. And if you want somebody to come for you, this may not be the channel for you. If you want somebody to lie to you, this is definitely not the place you need to be. If you want the truth, if you want that cold, hard, Blizzard King truth, somebody type Ice Lords in the chat room. If we inducting, if you want that truth that may not make you feel good, then welcome to the channel. Welcome. I'm not trying to sell you hope about this boy's case. I'm going to tell you what I believe the law is, and the record probably means, and where the problems are. That's what we do over here. Now, that being the case, yeah. If you learn something, I should earn something. But you don't owe me nothing. Now, let's just get down to the nitty gritty, baby. I'm not going to do all the videos I normally do and do the play-by-play. This is serious business, so we're going to talk about it. So the real issue, somebody type problem. Somebody type problem. The real issue in Karmelo Anthony's appeal. First thing people need to understand about Karmelo Anthony's appeal is where the case goes and what the appellate court actually is reviewing, okay? Because this was a Collin County criminal case. I think that's north of Dallas. The direct appeal would go to the 5th Court of Appeals in Dallas. Okay, not to be confused with the federal 5th Circuit Court of Appeals in New Orleans, which covers multiple states. We're talking about the 5th Court of Appeals. I think there's like 14 now. Houston actually has 2. It has the 1st Court of Appeals and the 14th Court of Appeals because Houston is so big. But the 5th Court of Appeals is up in Dallas. Okay, and if the 5th Court of Appeal affirms a conviction, in other words, they agree with the trial court, the next possible step would be a petition for discretionary review to the Texas Court of Criminal Appeals, which is the highest criminal court in Texas. All right, a lot of states have something called the Supreme Court. We have the Texas Court of Criminal Appeals, okay? Now, and that's discretionary. They don't have to take the case, but the appeal doesn't start with a motion, okay? Or what people think should happen. It starts with the record and the standard of review. Somebody type standard of review. Somebody type standard of review. Let's be intelligent. Let's learn something. Okay, the appellate standard of review. One of them is, or the appellate standard of review depends on the issue being raised. If the issue is legal sufficiency, this is going to be boring as hell, but you're going to learn something. Legal sufficiency of the evidence. The court reviews the evidence in the light most favorable to the verdict and asks whether a rational jury could have found the essential elements of the crime beyond a reasonable doubt. I know that's a lot of words, but the most important thing you need to listen to is light most favorable. In the light most favorable. In other words, we're going to give all the discretion to what the jury said. We're going to look at it in the light. If we looking at, okay, they could have made a mistake, but you know, maybe it wasn't a mistake. So in other words, the appellate court has given the jury's finder, the finder of fact, the benefit of the doubt. Okay? That's a very hard standard for a defendant to win because the appellate court gives the jury a lot of respect on witness credibility, conflicts in the testimony. Oh, but you said this that day. Well, the jury didn't believe it. Reasonable inferences from the evidence. And the appellate court isn't going to retry the case. The appellate court isn't going to sit there and say, well, I would have believed this witness instead of that witness. That's not how this works. And the standard is brutal for a defense lawyer or an appellate defense. It's brutal. The court looks at the evidence in light most favorable to the verdict. In other words, keeping the verdict. And it asks one question. Could a rational jury have found those elements of murder beyond a reasonable doubt and rejected self-defense? Based on the evidence that's publicly reported that went to the jury, the answer is yes. The verdict, that's what look, that doesn't mean you have to like the verdict. It doesn't mean you have to agree with the jury, but legally there's a major difference between saying, I disagree with the verdict and saying no rational jury could have reached that verdict. Those aren't the same thing. And on appeal, Karmelo Anthony's dream team doesn't win a legal sufficiency by arguing that some evidence supported self-defense. He only wins if he can show that the state's evidence was so weak that no rational jury could have convicted him. And that's not going to happen here because you have a murder weapon, a dead body, dozens of witnesses, and a confession. Now, that said, start with the crime itself, okay? The state has to prove murder. The state can prove murder if a person intentionally, knowingly causes the death of another person. Very simple to understand. The state can also prove murder if a person intends to cause serious bodily injury and commits an act clearly dangerous to human life and causes death. So we're going to break this down. I want you all to understand. Somebody type bootleg. I'm bootleg for telling you the truth. Right? Let's break it down. I've got me sweating. I'm sweating like a Hebrew slave out here. Screaming at the internet, ran my blood pressure up. Somebody type first element. Okay? First element, you're the prosecutor. The first element is identity. Do we know who did it? Right? And that's not a fight here. Because Karmelo Anthony was the person who stabbed Austin Metcalf. How do we know? Because he admitted it. Because you had dozens of witnesses. Somebody type sellout. Am I a sellout for saying that? It's the truth. He said he put hands on me. I stabbed him. So this isn't one of the cases where the defense can't say, can say you got the wrong person. It was his twin brother. It was a lookalike. This ain't it. Somebody type bougie in the chat room. So there's no issue as to identity. It was never an issue. The issue is whether the stabbing was a murder or legally justified. We can go past that. We got this one out the way. Identity, check. We know who it was. The second element, somebody type number 2, causation. And that's also a major problem for the defense. Austin Metcalf died because he was stabbed in the chest. How do we know that? Not because they saw the wound, but because the medical testimony reportedly showed that the knife entered the left side of his chest and pierced the right ventricle of his heart. That's not some speculative cause of death. That's not a complicated causation problem. That's direct. Knife goes in the chest, knife hits heart, Austin dies. A rational jury could easily find causation beyond a reasonable doubt. You see how that works? Somebody type sellout. Does that make me a sellout for telling y'all that? Huh? Does that make, You know, I'm asking questions. Huh? Does that make me a sellout? Huh? I don't think so. But if you choose to believe that, fine. Now let's talk about intent. Intent. Because this is where people online keep trying to blur the issue. Intent does not require a confession. Intent doesn't require Karmelo to say, I intended to kill him. Jurors are allowed to infer intent from conduct. In other words, we know you intended to do it based on what you did. Baby, I didn't intend to sleep with that woman. Well, you did it. I ain't mean to do it, but you did it. And she pregnant. And you came back to the house with some positive tests from the clinic. You meant to. Ladies, imagine your man coming back with your boyfriend or husband coming back with a new baby, talking about he ain't mean to do it. He didn't intend to do it. Well, what did you intend to do? I mean, did you trip and fall into it, sir? I'm just saying. So intent doesn't require for him to kill him. Just like intent doesn't, you didn't intend to have sex with this, get this woman pregnant, but you intended to do something. And that's enough. Is that easy to understand? Is that easy? Do y'all get that? And see, so the jurors are allowed to infer intent from conduct. And when someone pulls a knife and drives it into another person's chest, a rational jury can infer intent. The chest is a vital part of the body. The heart is in the chest. You don't need a law degree to understand that stabbing someone in the chest can kill them. And a rational jury, this is the standard, a rational jury could find that he either intended to kill Austin or knew death was reasonably certain or intended to cause serious bodily injury by committing an act clearly dangerous to human life. Is that clear? You see? And that's why this whole argument, well, he didn't plan to do it. He ain't planning. He ain't mean it. That doesn't get you very far. Okay? The law doesn't require a long planning session. The jury could look at the confrontation, the words, the refusal to leave, the knife, the wound, the location, and the aftermath, and conclude that this was not some accidental poke or harmless defensive movement. They could conclude that this was an intentional or knowing stab to a vital area of the body. He didn't stab him in the big toe, did he? There was a movie out called Harlem Nights. You guys remember that when Eddie Murphy was fighting the older lady and he shot in the toe? If she happened to die, he could say, well, I didn't intend to kill her. That's why I shot her in the baby toe. You see the difference? Had he shot her in the chest and said, oops, that was an accident, y'all be like, nah, you meant to do that. And see, here's another thing. The state also has his own words to work with. Witnesses reportedly testified that Anthony said things like, touch me and see what happens, or touch me and you'll find out. Now, standing alone, those words don't prove murder. But when you say something like that, and then a confrontation follows, and then you pull a knife, and then someone gets stabbed in the chest and dies, those words become evidence. Yeah, Della Reese. Eddie Murphy was shot Della Reese in the baby toe. But again, the jury was allowed to consider them as evidence of escalation, aggression, warning, threat, or intent. And this is where people need to be honest. You can't say, touch me and see what happens, and then someone touches you, then you stab that person in the chest, and then act shocked that the jury viewed the statement as important. That's not a minor detail. That's the kind of statement that prosecutors live for. It gives the state a clean narrative. He warned them about what he was going to do, and he did it. Now, the defense can argue that he didn't mean it that way. They can say, oh, he was scared. They can say he was warning people to leave him alone. They can say it was a teenage language, not a murder threat. Fine. That's an argument. But the jury didn't buy it. And the jury was allowed to say, no, we think that statement showed aggression. And under legal sufficiency review, somebody type legal sufficiency. And we talk about the legal sufficiency of the evidence. In other words, was it enough? Under the legal sufficiency review, the appellate court isn't going to come behind the jury and reweigh that weight. Does that make me a sellout for telling y'all that? Huh? Am I boule? Y'all always talk about, oh, well, you bring up Johnny Cochran was a member of Kappa Alpha Psi. Proud Kappa man. Does that make him boule? That's your hero. Thurgood Marshall was a member of Alpha Phi Alpha Fraternity Incorporated, like I am. But he's the reason you can drive down the street in white neighborhoods after dark and go to them white people. Thurgood Marshall's the reason you can date that white woman that you got right now, all you blackity black. Somebody type blackity black in the chat room. Somebody type blackity black. All you blackity blacks with white girlfriends curled up right now calling me a boule sellout. I can't stand y'all with your hypocrisy. Now let's talk about this self-defense because this is where the internet loses. Y'all losing your mind. Look, self-defense is not some kind of magic dust, okay? You don't say, he touched me first, and that automatically gives you the right to kill somebody. That's not the law. Deadly force requires more than being disrespected. It requires more than being told to leave a tent. It requires more than being touched. It requires more than being shoved. It requires more than feeling embarrassed or cornered. The question is whether Karmelo reasonably believed deadly force was immediately necessary to protect himself from Austin's use or attempted use of unlawful deadly force. Remember the standard. Because see, the real question is not whether Austin touched him, not whether Austin was bigger, not whether there was an argument, not whether Karmelo felt disrespected. The question is whether deadly force was immediately necessary. And if the jury believed Austin was unarmed, which they did, and wasn't trying to kill him, which they did, wasn't trying to cause him seriously injury, which they did. Shout out to Yardley. BK, thank you for being the first person to contribute to the super chat. Again, if the jury believed that Austin wasn't trying to seriously injure Karmelo, wasn't using deadly force, and wasn't committing one of the serious violent crimes that justified deadly force, then the jury had every legal right to reject a self-defense claim. You see how that works? The jury makes that determination. That's why I'm not speculating on things. I'm saying this is what the jury heard. This is what we're going to talk about. And see, that's what people don't want to deal with. When it comes to self-defense, even if Austin, quote unquote, put hands on Karmelo, that doesn't automatically justify a knife to the chest. A push isn't a death sentence. A shove isn't permission to stab somebody in the heart. A confrontation at a track meet doesn't automatically become a deadly force situation because somebody got touched. If the jury believed the physical contact was minor, if they believed Austin was unarmed, if they believed there was no group attack, and if they believed Karmelo escalated the situation by using a knife, then the self-defense argument is dead in the water. Who's mad about that? Huh? Y'all mad at me for telling you this is what the law says? Somebody type mad. Matter of fact, I hope you're super mad. Put a cape on. All the super mad. Put a cape on. This is the law. And another thing, size different, that it doesn't save him either. The defense could argue that Austin was so much bigger than Karmelo was. And Karmelo was seated and he was surrounded. They could argue that fear can be reasonable when you're outnumbered or physically smaller, but size difference alone does not justify deadly force. Being smaller doesn't give you a free pass to stab somebody to death because you're scared. The jury considered size difference and still said it wasn't enough. And that's legally their call to do that. Now, the evidence also showed that Karmelo was under another school's tent. And he was asked to leave repeatedly. That gave the state a strong narrative. Again, being in the wrong tent doesn't make somebody guilty of murder, but it helps the state frame the confrontation. The state can say he was there, he wasn't supposed to be there, he was asked to leave, he refused, he escalated verbally, and when the confrontation turned physical, he used a knife. That's a simple story for the jury to understand. It should be simple for y'all to understand. And see, and what about the stabbing itself? This wasn't a punch. This wasn't a slap. This wasn't pushing somebody back after they pushed you. This was a stab to the heart. And that's why the self-defense argument had a hard time. Deadly force has to meet a deadly force standard, and Austin didn't have a weapon. Austin wasn't using deadly force. There wasn't a serious threat of death or serious bodily injury. So the jury could and did rationally say that the response was crazy, wildly disproportionate. Look, man, just because somebody put your hands on you and you told them not to, that doesn't end the case. That's not a legal shield. And the jury can believe the part where he admitted the stabbing and rejected the part where he claims justification. A defendant doesn't get to define the case just by saying, I was defending myself. Shout out to Packanaut. You understand that? I defending myself is not a free get out of jail card. The jury gets to decide whether that explanation is reasonable. And here the jury rejected it. Y'all need to stop, and also stop acting like manslaughter was automatic. And shout out to 1001 Bone. This is the truth. You want to hear the truth, or you want me to lie to you? I could lie to you like the rest of these people on the internet. Would y'all like me to lie to you? Oh yeah, man, it's gonna be a great appeal. He's got a dream. I can lie to you. I can do that. Is that what you all want me to do? You want me to lie to you? Would that make you feel better? Somebody type feel. And you want to feel good, or you want to know the truth? Let me know. Oh, you're on the side of Austin. I'm on the side of accuracy. I'm on the side of truth. It should be refreshing to have a lawyer sit here and tell you the truth. Who would you rather have? A lawyer that takes your money and lies to you and tell you what the outcome is going to be, and then you realize, damn, that dude just took our money, and you still end up going to jail. Is that what you want? There's plenty of lawyers out there that do that. I'm not one of them. I'm not going to take your money. I'm not going to waste your time. I'm going to tell you, this is what's going to happen. It's a bad case. We can work with it. What would you rather me do? Well, I'm just asking, what would you rather have? What kind of lawyer? You see why lawyers have a bad reputation? You all want them to lie to you, and I'm not going to do it. Again, I'm not going to waste your time. I'm not going to waste your money. I'm going to tell you the truth. Now, if you can't handle that, if you don't like that, maybe this is not the channel for you. Maybe you need to go find somebody who's going to cater to you and make you feel good. I'm not that guy. And any other professional, lawyer or doctor, you want your doctors to lie to you? Oh, yeah, you're not fat. You 358 pounds, 5'2", with high blood pressure and diabetes. Oh, you're the healthy as an ox. Is that what you want? How about your pastors? You want your pastors to lie to you? No, girl, go on out there and have all the kids you want. Jesus said it was okay. Is that what you want? Would you prefer people to lie to you? People whose society has invested authority and knowledge. You want to, is that what's going to make you feel better? Because apparently lying to you, don't call the lawyers who are lying to you and making you feel good. You're not calling them sellouts and boulets. No. But the one who's telling you the truth, telling you to act accordingly. Oh, he's boulet. He's for the other side. I want y'all to process that. Y'all think about that. But again, let's get back to this manslaughter. Manslaughter in Texas is reckless killing. But if the jury believed Karmelo intentionally or knowingly stabbed Austin in the chest, they didn't have to compromise on manslaughter. Pulling a knife and using it on someone's chest can be viewed as an intentional or knowing conduct. And a rational jury could say this wasn't merely reckless. He meant to use that knife. He used it in a way that was clearly dangerous to human life. He didn't stab him in the shin. He didn't stab him in the baby toe. He stabbed him in the chest. What does that tell you? Anybody with common sense? That's clearly dangerous to human life, and that supports murder, and a rational jury could come up with that. And look, and a sudden passion doesn't magically erase murder either. Sometimes people get convicted manslaughter because they come in the house, she saw her boyfriend cheating with her neighbor, and she shot and killed both of them. She got manslaughter. That's a sudden passion, a sudden hot flash of blood. You can't control yourself, right? And sudden passion may affect punishment in the right case, but it doesn't make the killing lawful. If the jury believed Karmelo escalated the confrontation, threatened Austin, refused to leave, and used deadly force when deadly force wasn't necessary, then the jury could reject any attempt to soften the case emotionally. And that's what they did. Anger, fear, embarrassment, and teenage stupidity don't automatically reduce the case from murder. So when an appellate lawyer looked at this legal sufficiency of the verdict, then they got some serious problems. And this is why this is important. Because if the evidence is legally insufficient and the jury, a rational jury, couldn't come to that verdict, then the verdict is overturned. The boy gets sent home. That's what happened in the Bill Cosby case. That would be the strongest and best that no rational jury could believe that this case, he was proved guilty beyond a reasonable doubt. But they don't have that here. Because again, you got a dead body, a knife, dozens of witnesses, and a confession. And I don't want y'all to forget that. Are y'all hearing me? You got a dead body, a murder weapon, dozens of eyewitnesses, and a confession. In what state does that person not go to prison for a long time? You let me know. Name the state where that person doesn't go to prison. Have y'all seen the first 48? Do you know how this goes? All they need is one witness. Yeah, man, Leron and them did it. Oh, yeah, we're going, yeah. You for a cheeseburger, Happy Meals, and French fries and a shake, man, you can get them to snitch on all their homeboys. And the people go to prison forever. And you got all this. I'm just saying, this makes me, I'm the bad guy for telling you the truth. Would you rather me lie to you? Let me ask you again. Would you rather me lie to you? I can lie to you. Would you like me to lie to you? If it makes you feel better, I'll start lying to you all every night. But again, I didn't get 100,000 subscribers by making people feel good. I got 100,000 subscribers with no viral videos, just sitting here in this little blue sport coat and that wall behind me. That's it. No special guests, no entertainers. I don't even think I have a video over 70,000 viewers. You understand? Huh? I don't talk about relationships, nothing sexy over here. Nothing at all. Hell, I've been on a constant YouTube shadow ban for 6 years. Shout out to Hennessy Bastion. You understand what I'm saying? Some people say, well, you got some viral video. No, I don't. Not on this channel. Maybe some other people might have some viral videos on their channel, like Willie D, but I don't have them here. Not me. But again, let's move on. Somebody type move on in the chat room. Let's move on. So the evidence was sufficient. So we can agree, and I'm going to tell you now, we can agree that this appeal is not going to be turned over because the evidence was insufficient. It's too much of it. It's too much. Now here, let's talk about this. Ineffective assistance of counsel. Somebody type bad lawyer in the chat room. Somebody type bad lawyer. He had a bad lawyer. That's how common folks say. Somebody type bad lawyer. Bad lawyer. Let's talk about ineffective assistance of counsel because this is where a lot of people online are about to get their feelings hurt. I'm going to hurt all of your little funky feelings. Come on in. Come on, all my couch lawyers, all my, come on in. Y'all read one case 15 years ago. You think you know everything about the practice law. Come on in. Come on in. Somebody type bad lawyer. Bad lawyer. Ineffective assistance of counsel. People keep saying Karmelo Anthony's lawyer was ineffective. Shout out to Roll of Tape. That's what you're saying. They said he should have testified. He should have put Karmelo up there to testify. You put this 19-year-old up there to testify. They say the lawyers didn't object enough. Woo-wee. They say the lawyers didn't fight hard enough. What were they gonna do? How hard were they gonna? How much hard fighting did they have to do? What was gonna hide that body? Somebody type bad lawyer. A body, a dead body, a knife, dozens of witnesses, and a confession. Somebody type bad lawyer. He just went to jail because he had a bad lawyer. That's what y'all think? They say the lawyers got outworked. Mm-hmm. They said the lawyers sold him out. Ineffective assistance of counsel. It's one of the hardest claims to win. Do you not know that if ineffective assistance of counsel was easy to win, it would be part of the legal strategy? Do you not realize that that's what would happen? Lawyers all, well, if we look like we're gonna lose, what I'll do is I'll just come to the courthouse drunk and then just sleep through the opening and the closing and the cross-examinations. You realize that? But anyway, it's one of the hardest claims to win, and it comes from a case called Strickland v. Washington. And under this case, the Supreme Court, the defendant has to prove two things. Somebody type two things. First, he has to prove that the lawyer's performance was objectively deficient. And what that means in plain English, that means the lawyer's work was so damn bad, not just questionable, not just unpopular, like you all is unpopular, right? Right? Not just unpopular, but outside the range of reasonable professional judgment. Okay? Second, the defendant has to prove prejudice. What does that mean? That's a hard one. That means he has to show a reasonable probability that, but for the lawyer's being a bad lawyer and his mistakes, that the result would have been different. You understand what I'm saying? Think about that. If it wasn't for the lawyer objecting, right? The lawyer should have objected more. They shouldn't have been able to introduce that dead body and that murder weapon and all 21 of those eyewitnesses and that confession. Had the lawyer objected more, that evidence wouldn't have come in. Is that what y'all think? I'm just asking questions. And see, that part is where most of those ineffective assistance of counsel claims die. Because the Supreme Court has made it very clear that a defendant has to show both deficient performance and a reasonable probability of a different result. And it's not enough to say, I would have tried the case differently. It's not enough for some lawyer who has nothing to do with the case to come on and say, well, he should have did this. He should have objected here. See, courts give, shout out to Joy Campbell, courts give trial lawyers a lot of room because trial strategy is messy. Lawyers make judgment calls. Some work, some don't. And appellate courts are very reluctant to second guess who those decisions after the verdict. And here's the cold part. The courts have had cases where lawyers were accused of sleeping during the trial, being drunk, being high during the trial, or doing almost nothing. And the defendant still couldn't prove ineffective assistance of counsel. Can you imagine that? Your lawyer is drunk as a skunk and high as a Georgia pine, and you about to go to prison for 50, 60 years. And you try to appeal on ineffective assistance of counsel, and nah, just because he was asleep, that wouldn't change the outcome. They caught you with the dope, the gun, and your homeboy snitched on you. You going to prison. You understand what I'm saying? Are y'all listening? Did you hear that? Your lawyer could be drunk, high, and sleep at the same time during the whole trial, and you still gonna stay in prison if you appeal on ineffective assistance of counsel. The Marshall Project reported that defendants who claimed their lawyers were drunk or high have found it extraordinarily difficult to win because courts still require them to show that the trial outcome would likely have been different with a better, sober, not high lawyer. And that tells you how brutal this standard is. If the court looks at the evidence and says, even with a better lawyer, Yo behind, the jury probably still would have convicted you. Then the ineffective assistance to counsel, it falls flat on its face. Do you hear what I'm saying? Somebody type boule in the chat room. Somebody type sellout in the chat room. I'm a sellout for telling y'all that, right? Would y'all like to hear that? Or you want me to lie to you? I can lie to you. Would you like me to lie? I'm just asking questions. Would you like me to lie to you? Let me run that back. There are sleeping lawyer cases that show exactly how hard this is. It's one out of the 11th Circuit. A case, a defense lawyer admitted he fell asleep during part of the recorded statement that was played for the jury. The defendant had been convicted of murder and armed burglary. Okay, but the court still rejected the ineffective assistance of counsel claim because the lawyer had otherwise cross-examined the witnesses. He objected. He participated. He just went to sleep through the parts that didn't matter as far as the court was concerned. And the court treated that as a non-critical portion of the trial. Imagine that. Your behind is on trial for your life. And the court said, well, that wasn't even critical, man. Yeah, he could take a nap during the recorded statement played for the jury. That wasn't important. They turned the lights out. He old, went to sleep. He losing his tie up, got his little water. He's sitting there snoring. And you looking over at him, you got your little handcuffs on, and you looking over at him like, hold on, you need to wake up. Oh, that's not important. And so he appealed it. And they said, nah, that wasn't important. He objected a couple of times. He cross-examined some witnesses. He could take a little nap. This is a murder trial. Think about that. A lawyer fell asleep in a murder trial and the conviction stood. So when people say Karmelo Anthony's lawyer should have done this, or Karmelo Anthony's lawyer should have done that, he should have objected more, understand how far away that is from winning an effective assistance. You got to show more than just bad optics. You got to show constitutionally deficient performance and actual prejudice. Now, let's talk about an extreme. I'm going to give you an example where you can do it. This is an extreme case where the sleeping counsel came. It led to some actual relief. The gentleman's name was Calvin Burdines. It was a Texas death penalty case. It became famous because the lawyer slept through the substantial portion of the trial and the sentencing. And his conviction was eventually overturned, and the ACLU noted that the state had even argued that a sleeping lawyer was good enough. You hear me? Your lawyer could be asleep in the state. That's not bad. But see, the case proves the point. It took extreme facts. It wasn't just my lawyer blinked too long. It wasn't my lawyer looked tired. It was a substantial sleeping. In other words, you got a capital, the stakes are high. You got a capital murder case, and your lawyer basically came in and sat down and went to sleep during the whole trial. Okay? And the state said, well, that's still, I mean, he murdered somebody. We got evidence. He's going to prison. And they gave him a new trial. Okay? But people confuse possible lawyer mistakes with automatic ineffective assistance of counsel. And they're not the same thing. A lawyer can make a whole bunch of bad calls and still not be constitutionally ineffective. A lawyer can choose not to call the defendant and still not be ineffective. A lawyer can fail to object to some things and still not be effective. A lawyer can try a weak strategy and still not be ineffective if the court thinks it was within the wide range of reasonable trial strategy. I remember I tried this case in federal court. I was a young lawyer, young and stupid. Depending on the court you in, it depends. The rules can be a little bit different. Everybody has a different vibe, and you kind of pick up on the case. I was objecting too much. And so my co-counsel said, you objected too much. And I'm like, what you mean? He shouldn't be asking those questions. That's his witness. Those are leading questions. And he said, you can't say that because you object so much, then the jury doesn't like you. You wasting their goddamn time. They don't want to be there. You hadn't considered that, huh? That's because you lay people wouldn't. You non-lawyers wouldn't consider that. You objected too much. And now the jury's mad because we still got 4 or 5 more witnesses and they got to be here for the next couple of days and you keep objecting every damn time. They don't like it. You object. You tell why. The other person tell why. The opposing counsel explains why. your objection should be overruled and the judge rules, and then they get back to the questioning. That takes a long time. So again, that's the truth. There may be a strategy behind not calling Karmelo Anthony to the stand. I don't know what it is. I can imagine. Hindsight is 2020. But there's a wide range of reasonable trial strategy. And see, that's especially true on a direct appeal. Ineffective assistance is usually hard to win on direct appeal because the appellate court often doesn't explain why the lawyer did what he did. Maybe the lawyer didn't put Karmelo on the stand because there were some prior inconsistent statements that he had made. Maybe the lawyer was worried about cross-examination. Maybe there was some damaging evidence the public doesn't know about that they didn't want to come out in the jury. Hell, he might have got up on the stand, and instead of getting 35 years, he might have got 75 years. Y'all keep playing. Keep on playing. Hell, maybe Karmelo didn't want to testify. Maybe counsel made a terrible decision. But if the record is silent, the appellate courts usually don't assume incompetence. They assume there has to be some reason behind it. Now, could Karmelo eventually raise an ineffective assistant counsel? Yes, he can do that, absolutely. If a trial counsel failed to investigate and failed to prepare him to testify, and he testified, or failed to object to some obvious legal error, or failed to request the proper jury instructions, failed to challenge the improper witness testimony, or failed to preserve some major appellate issue, then his appellate, and he can do that. They'll look at that. His dream team will look at that. They'd be foolish not to. But will it be easy? No, not even close, because the state's response will be simple. Even if the lawyers made mistakes in this case at the trial level, the evidence is still overwhelming. We got a dead body, dozens of eyewitnesses, a murder weapon, and a confession. So the state will argue that there's no reasonable probability that the outcome would have changed, even if the lawyer was asleep the whole time, much less not objecting enough for you all. That's the wall that they have to climb. So here's the hard truth. Somebody type hard truth. I know y'all mad. Somebody type sell out in the chat room. Boule. Somebody, come on, let's get all them words in. You mad? Be mad. I don't care. Here's the truth. This ineffective assistance of counsel is possible, but it's unlikely on this direct appeal. If it had legs, it's probably later in an Article 11.7 habeas proceeding where the new lawyers can build a record to show what trial counsel actually failed to do. But right now, on this direct appeal, just saying the lawyer did a bad job, it's not enough. It's not enough. And that's what it is. Let me know when you're mad. If you're mad, just turn the channel off. Go somewhere else. Somebody will lie to you. I don't want you to feel good. I want you to be upset, hot, and bothered. Yeah. Ha ha. I want you to be good and mad over here. You're going to get this truth. You're going to like it, whether you like it or not. Y'all see my cup match my little picture behind? Look at that. See that little picture? It's nice, huh? Coordinated. But anyway, y'all still here? Y'all still with me? There's a lot of y'all in here. There's a lot of y'all in here. You want the truth, right? That's why I asked you earlier if you wanted the truth. Right? Okay. Let's continue. Shall we continue? I'm saving lives over here, baby. Uncle D is saving lives. Tell you the truth. I ain't gonna lie to you. Right? Some of you all studying for law school, you get ready to go. You can learn something over here, baby. You can learn something for free. I'm not even I should start charging y'all for these law school classes, man. I should. This is a level 3. This is a 3L class, appellate lit. But anyway, you know, there's been a big ado. There's been a lot to do. The fact that Karmelo Anthony jury had no black jurors, no blacks. Somebody type no black, me no black jurors. Okay, but no black. Just because you don't have any black jurors in the jury, that's not enough by itself. Now, Karmelo didn't have an all-white jury. It was some brown people, Asian people on there, okay? But hell, even an all-white jury, standing alone doesn't automatically prove the Batson violation. The Constitution doesn't guarantee a defendant a jury of his race. The issue is how the jury that's it. The only issue is how the jury became all white or how all the blacks were excluded. That's the reason. Shout out to 99 Problems. And let me explain something, because I want to talk about Batson. Somebody type Batson in the chat room. Batson, like Batman, Batson. It was about stopping prosecutors from doing indirectly what the Constitution says they couldn't do directly. Batson v. Kentucky. This is a U.S. Supreme Court case. It was issued in April 30th, 1986. I remember when it came out because my daddy talked about it. I remember the conversation he had with it was revolutionary. Like, wow, it's amazing. Like, damn, really, Daddy? Yeah, it's amazing. Yeah, it's all the black people. You go down there and try a case, there's no black people in the jury. The prosecutors exclusive. The peremptory strikes. You got strikes for cause and peremptory strikes. A peremptory strike, each side is issued a certain amount, sometimes 3, sometimes 4. They can strike as many people as they want up until the limit of those peremptory strikes. Strikes for cause means there's some substantial reason that they want to strike this person. Those you kind of have to go over. You got an unlimited amount of strikes for cause and a limited amount of peremptory strikes. But the bottom line is it's like a free a joker. You can just get rid of that. You got the high joker. You got 4 high jokers. Bomb, 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 bomb. I'm out. You see, that's a peremptory strike. Get them out. You don't even have to explain. And so prosecutors were using that to get rid of black people. Okay. And so this case, Batson v. Kentucky, it went up to the Supreme Court and they issued a ruling in April 30th, 1986. And the case came from the trial of James Kirkland Batson. He's a black man from Kentucky, okay, with burglary and receipt of stolen goods. And during the jury selection, the prosecutor used peremptory strikes to remove all 4 black prospective jurors from the jury pool. And so Batson was then tried by an all-white jury in Kentucky, and as you can imagine, he was convicted. And he challenged that. He said, look, the state violated his constitutional rights by removing black jurors because of race. And the United States Supreme Court agreed. And they said under the Equal Protection Clause of the United States Constitution, it forbids the state from purposely excluding black jurors because of race. And the court made it clear that a black defendant does not have a constitutional right to a jury made of black people. Okay, but he does have the right to a jury of black people. In other words, you have a right to a jury of your peers, not a jury of your peeps. Okay, you understand that? You have a right to a jury of your peers, not a jury of your peeps. And the prosecution can't just remove black people. Now, according in the Karmelo Anthony case, according to CBS News Texas, the jury pool started off with 589 people. All of these are prospective jurors. This is a jury room full of people, okay? After the jury selection, all the qualified black jurors were dismissed by the prosecution. And CBS reported that the prosecution argued the circumstances were race neutral, which is what you expect them to do. We didn't get rid of them because they were black. We got rid of them for other reasons. That one had a wooden leg and a kickstand. That one over there said she had baby daddy issues. And this one right here said his car was on flat. He needed to go down to the Jiffy Lube to get his car checked out. He didn't want to serve it. Race neutral. I know that's, I know those are race neutral, right? And then, you got the defense attorney looking at him side like, I don't know about that, right? But anyway, so that's the issue. Not just the final racial makeup of the jury. The issue is whether the prosecution uses strikes to get rid of the black jurors and then offered explanations that don't hold up. So you had News One reported that the prosecutors used peremptory strikes. Shout out to Black Sands. The prosecutors used peremptory strikes to remove the last 3 remaining black prospective jurors, despite the defense raising the Batson challenge. And it also reported that the prosecutor said that those black women were removed because they were educators of school-age children. Listen to that. They were educators of school-age children. I want you to remember that. That's why they said that sounds pretty race neutral. Okay, it's race neutral. They were educators of school-age children. Okay, and so they were moved because of that. And the judge accepted that explanation. And see, this is where the appellate lawyers, somebody type dream team, this is where they need to dig in. Because educator, it sounds race neutral, okay, on its face, because you can have white educators, Asian educators, short educators, tall educators, whatever. But that doesn't automatically end the analysis. The next question is whether that reason was applied evenly. Listen now, I want you to learn something. Listen, did the state also strike white educators? Did they strike Asian educators? Did they strike Hispanic educators? Or was it just, in other words, did they strike non-black educators? Did the state leave white teachers or white parents or of school-age children on the panel? Shout out to Terrell Stips. Were the black jurors questioned differently? Were their answers actually problematic, or did they state, or did the state just need a reason after the fact? Now, one thing you'll notice, typically we as lawyers, we pick on the jurors we don't want. We'll ask it. If we don't want them, we don't want that one. We're going to ask them a bunch of questions and hoping they say something that we can get them out of here on. You see? So just keep that in mind. So if you're ever doing a voir dire and you see the lawyer picking on a particular person, they probably don't want that one. Now, in some cases, they'll use them to kind of fish answers out of the other jurors. They'll get this one talking, and then the jury will start talking amongst themselves. And then we can learn from that because you got a limited time, okay? And it's better to get them to speak freely to each other so you can hear what their responses. And you over there writing down, I'm gonna get that. You gotta go. Engineer, they gotta get out of here, okay? So where the answers actually, so that's how you attack Batson ruling, okay? You don't just yell racism and expect a conviction to fall. You compare jurors. You look at the strikes. You look at the prosecutor's questions. You look at the answers. And all of this is being recorded by the court reporter. This is the voir dire transcript, okay? You look at the answers. You look at the similarly situated white jurors. Why weren't they struck, right? You look at whether the state's explanation makes sense or whether the clean sounding excuse covering a dirty result. See, if the record shows that the state struck black jurors for reasons that also could have applied to the white jurors that were sitting right in there with them, right, who were allowed to serve, then that's a problem, somebody type of problem. If the record shows that the state's reasons were vague or inconsistent or unsupported, that's a problem. Somebody type problem in the chat room. If the record shows that the trial judge just accepted the state's explanation without serious analysis, that's a problem too. Well, whatever. I got a golf appointment later on. I'm out of here. We got to get this over with. Okay, you understand? But see, Batson is hard to win on appeal. It's available, but it's still hard to win. See, the trial judge gets deference because the judge was sitting there. He was watching. He saw the jurors. He heard the tone of their voice, right? The judge watched the lawyers. The appellate courts usually don't like second guessing those credibility calls. So Anthony's dream team of lawyers, can't win this issue just by saying there was no black jurors. They need to show that the prosecution's race neutral reasons were just pretextuals. In other words, that means they were fake. That means that means not the real reason. And if the state's reason was that the black jurors were educators of school-age children, and then the appellate team needs to hit that reason real hard because, see, this case happened at a school track meet. Shout out to Yvonette. It happened at a track meet, school track meet, but the victim and the defendant were high school students, so the state might argue that the educators with school-age children could be emotionally connected to the school setting, student safety, or youth violence. And that's important. That's facially neutral, right? You wouldn't want a bunch of people thinking about, well, what if that was my kid? Okay, what if that was my child, right? What if they could be sympathetic? And they've already done jury polls in the community to see how people feel. You don't think they figured out how people felt already? They did. Okay? So on his face, it's racially neutral. We see that. But see, here's the thing. right? And the defense response is obvious. If the reason is real, show us that you struck everybody who fit that category. Did you strike the white women who were educators with school-age children? Did you do that? We don't see where you did that. Huh? Don't just strike the black women when and then suddenly discover a concern about educators. If white educators, white school employees, white parents of school-age children, or white people with similar concerns were allowed to remain, then the state's explanation starts to look like a lie. It starts to look like cover, right? Y'all see that rationale? See how that works? This is Batson right here. You see, the prosecutor can say race-neutral words, but can those words survive comparison? If the reason applies to black jurors but not white jurors, that's not a reason. If the last qualified black prospective jurors were struck by the prosecution and the final jury had no black jurors, then the appellate team absolutely needs to attack that record. Absolutely. Surgically, they need to go juror by juror. They need to strike by strike, answer by answer, comparison by comparison. The strongest Batson argument would sound like this. This case involved a black teenage defendant, a white teenage victim. You got an intense racialized public national attention and a jury selection process where the prosecution removed the remaining qualified black prospective jurors at the last minute. The state then offered race-neutral explanations. But the question for appeal is whether those explanations were genuine or whether they were just fake, or as we say, pretext. If similarly situated non-black jurors, white women, were allowed, Asian women were allowed to serve while black jurors were struck from the same supposed reason, then the defense is something real. That's a strong Batson argument. But a weak Batson argument is that there were no black people on the jury, so the verdict is racist. That's not enough. It's not going to work. I know that's what y'all are saying on the internet, but that's not going to fly. That's going to work. That works on social media, but it's not going to win Karmelo Anthony's new trial at the Fifth Court of Appeals. The appellate court needs a legal record, not a slogan. So if I'm analyzing this appeal, I'd say Batson is one of the most important issues to watch. It's not going to be a cakewalk. It's not going to be easy. Okay? If that comparison exposes unequal treatment, then this becomes more dangerous for the state. And again, Batson versus Kentucky came about because prosecutors all across the nation had a history of using their peremptory strikes to get black people off the juries. And that's not conspiracy talk. That's why the Supreme Court created that rule. And in Karmelo Anthony's case, the appellate issue is whether that happened here. Not whether people are mad, not whether the jury looked bad, not whether the internet thinks the case was racial. The legal question is whether the prosecution struck black jurors because of race and whether the reasons they gave were real or fake. That's where the fight is. Okay? That's what the fight is. All right? Are y'all mad? Somebody type sellout in the chat room. Somebody type house Negro in the chat room. Somebody type boule. All I did was tell you the truth. Y'all still mad about that? Let me know. Let me know if you're mad about that. Does that make you angry? Does that make me a raccoon for telling y'all? Again, I could lie to y'all. If you want me to lie to you, let me know. I respect you enough to tell you the truth. But if you would like me to lie to you, just let me know. I'm here for it. I'm here for whatever, man. I'm here for it. Let me know. Is that what you all want me to do? You want the truth or you want me to lie to you? What do you want? Truth or lies? There's plenty of people, like I said earlier, there's plenty of folk out here who they'll lie to you and they'll get your little feelings up and make you feel good. That's not what I'm going to do. Not going to do that to you. I respect you enough to tell you the truth. That's what type of attorney I am. Hell, that's what type of man I am. Straight up. Not going to lie to you. At all. Shout out to all the people who contribute to the Super Chat, the Cash App, and the PayPal. I appreciate y'all. Thank you so much. I'm going to read all these Super Chats in a minute. Y'all still with me? Yeah, y'all still, let me know if you're still with me. I got a little bit more I want to talk about. I want to kind of bring this on home. Have I been, this is complicated stuff, by the way, you guys. This is stuff that lawyers don't even learn. Well, law students don't even learn till they get to like their third year law school, mostly. Either second year, third year law school. So these are some very complicated subjects. So if I've lost you, that's okay. Okay? If I lost you, it's okay. This is not something that's typically the public is exposed to, so that's okay. But here's the thing. You know, Karmelo, he has issues. His appellate court lawyers can raise. They can talk about Batson. They can talk about a jury charge. They can talk about legal sufficiency. They can talk about improper witness opinions. They can talk about the judge possibly rushing the jury. There was some internet rumor that he told the jury, if y'all don't hurry up and come up with a verdict, I'm going to put all y'all in a hotel. They can talk about prosecutorial misconduct. They can talk about ineffective assistance of counsel. They can talk about punishment, mitigation. But people need to understand something. Having an appellate issues is not the same thing as having a winning appellate issue. You understand the difference? Having an appellate issue that gives you a good faith-based grounds to appeal does not mean that is a winning appellate issue. Okay? Does that make sense? There's a difference. That's the hard truth. Every one of these issues is difficult. Legal sufficiency is hard because the appellate court views the evidence in the light most favorable to the verdict. In other words, judicial economy says we want to keep this verdict intact. Y'all went through all this trouble to get a trial and get a jury, and you got it, and we don't want to disturb it. So we're going to look at this verdict in the light most favorable to the jury. That means the court gives the jury every reasonable inference that supports the conviction. Karmelo admitted to stabbing Austin Metcalf. Does that make me a sellout for saying that? The wound was in his chest. The knife hit his heart. Does that make me a boule for saying that? It's the truth, right? The jury heard that evidence. They heard that Austin was unarmed. Does that make me a raccoon for saying that? That's the truth. Y'all don't want me, you want me to lie? Y'all want me to say that it was Austin's knife. I know, that's what you want me to say. It was Austin's knife, and Karmelo disarmed him and took his knife. And but for that, Austin would have stabbed it. That's what, I can lie. I can make up some tall tales if you want me to. Some aliens came from outer space and pushed Karmelo into him and took over his brain. I can lie. If that makes you feel better, I can tell you all the lies you want to hear. Is that what you want to hear? That's like the lawyer said, oh man, you got a great case. We're going to get you off. All you need to do is just give us $100,000 down payment and we'll help you beat this shoplifting charge. Is that what you want? I'm just asking questions. I'm just asking questions. Huh? Is that what you want? I can lie to you. I'll make you feel good. You want me to feel good? I'll make you feel good. It won't be the truth. And you'll be very disappointed when the truth comes out. At least now you can get prepared. That's one of the issues. Batson is another one, right? Self-defense. I mean, what are you gonna do? Again, as I say, Batson, you got to show that you got to show that it's not just enough to say not just enough to say we got all a white jury or they struck all the black jurors. They have to deal with the state's race neutral explanation. Shout out to 99 Problems. They have to show those explanations were fake. And on appeal, the trial judge gets deference. In other words, we're going to believe him unless you show us why we shouldn't. Absolute evidence to show us why we shouldn't. So again, Batson is the best argument. And it sounds powerful to the public, but it's a record-heavy, fact-specific fight. That evidence might not be in there. Then there's this jury charge issue. There's this jury charge issue. People keep bringing that up. I don't even know if that's true. Have y'all seen the jury charges? But the appellate court will actually look at the written jury charges. Did somebody mistake the law? I don't think that's probably going to be hard to prove. Pretty easy. All they get the same template they've been using for years. Did it improperly limit self-defense? Did it confuse the jury? Did it shift the burden? Did the defense object? If the charge was legally correct, this issue goes nowhere fast. If the charge was wrong, but nobody objected, the standard gets much harder. A jury charge is just a piece of paper. It's like 20 pieces of paper with all the law, and the judge reads it into the record. He typically goes over it and over again, him and the law clerks. They'll give a copy to defense counsel and the prosecutors. And they'll look at it and make sure it's accurate. I don't know. Improper witness opinion testimony. I understand that they asked all these lay witnesses whether or not they thought it was self-defense or not. So they might say, well, that's improper witness opinion, that they're not allowed to give expert testimony. And whether something is self-defense or not is a legal decision. But again, preservation matters. Did the defense object each and every time? Did the judge rule? Did the testimony actually affect the verdict? Shout out to Big J. Again, if all that happens, then it becomes much weaker. On appeal. Judicial coercion. That's another issue people keep raising up. If the judge pressured the jury to hurry up, because remember, this trial lasted 4 days. That was quick. I think they deliberated for about 4 hours. And there's some rumor that the judge told them, well, yeah, if y'all don't hurry up and come up with this ruling, you're going to stay in the hotel tonight. And in that regard, did the judge pressure the jury to hurry up? That could matter, but the exact words matter. A judge can talk about scheduling. A judge can discuss logistics. A judge can tell jurors what happens next. And that's called sequestering, by the way. A judge can tell jurors what happens next. A judge can can't do it. He can't pressure them to hurry up and reach a verdict. Not like that. So unless the record shows real coercion, not just discomfort or inconvenience, this issue is not going to go far either. And what about prosecutorial misconduct? I don't know. That's what you're saying. They may not, people may not like the prosecutor's tone. They may not like arguments. They may think the state was unfair, but that doesn't automatically equal reversal for misconduct or reversible misconduct. The defense actually has to object, ask for an instruction, and sometimes move for mistrial. If they didn't, the issue gets waived more likely than not. And even if there was misconduct, the appellate court still asks whether that even would affect the trial. Because you got a dead body, a murder weapon, dozens of eyewitnesses, and a confession. So did that really affect the trial? Did that affect the evidence? That's what they're saying. Ineffective assistance of counsel, I talked about that. It may be an issue people yell about most. I heard y'all on the internet. You don't win ineffective assistance of counsel by saying the lawyer looked bad on the internet. You have to prove deficient performance and prejudice. You have to show the lawyer's work fell below constitutional standards, and the outcome probably would have been different. That's a brutal standard. Brutal standard. And because the trial record usually doesn't explain why lawyers made certain decisions, ineffective assistance of counsel often fits better in a habeas corpus non-direct appeal. Look, even the punishment is also hard. 35 years sounds like a lot, but murder carries a wide punishment range in Texas. So the sentence itself is not automatically illegal or reversible. The better punishment argument would have to be about improper evidence, bad punishment instructions, or lack of mitigation or ineffective assistance. Again, it depends on the record. So the big picture is this. None of these issues are easy. Not one of them. Okay? None of them. Not one. It's going to be hard. It's going to be very hard. I'm not saying the appeal is impossible, but it's going to be very hard. And the appellate lawyers may find something real in the transcript. Maybe the Batson record is stronger than we know. Maybe the jury charge has a real defect. Maybe the judge said something improper to the jury. Maybe the trial counsel failed to preserve some obvious errors. Maybe there are habeas issues later. But right now, nobody should be selling people false hope, and I refuse to do it. I'm not going to do it. I'm not going to lie to you to make you feel better or try to keep y'all from calling me names. I'm going to tell you the truth over here. It's all I do. I take pleasure in it. I'm not here to sell you false hope. Appeals are not won by outrage. Appeals are not won by vibes. Appeals are not won because people think the trial was ugly or unfair. Appeals are won by preserved legal error and that cause harm. That's the problem with this appeal. A lot of issues sound strong when people talk about them online. But once you put them inside an appellate standard review, they get weak. And once you ask whether the issue was preserved, they get weaker. And once you ask whether the trial judge gets deference, they get weaker than that. And once you ask whether the error actually changed the outcome, they just disappear. Again, you got a dead body, a murder weapon, dozens of eyewitnesses, and a confession. That's the reality. So yes, Karmelo Anthony has an appeal, but every issue has a wall in front of it, a big one. Legal sufficiency was the jury rational based on the evidence? Batson has a pretext and deference problem. Jury charge error has a preservation problem. Witness opinion testimony has an objection problem. Judicial coercion has the exact wording problem. And prosecutorial misconduct has a preservation problem. ineffective assistance of counsel has that Strickland problem. You got to be, he was drunk and sleep and still no ineffective assistance of counsel. And that's why I keep saying the same thing. Look, man, I'm not going to lie to you. This appeal lives and dies on the record, and the record is ugly. If the record was strong, he had a fight. If the record is weak, all this internet outrage in the world is not going to save this boy from doing his time. Now, I have a couple more things to say, but I want to take the opportunity to read these super chats to all you good people. Thank you, everybody. I want to read them, and we're going to ease on. Have y'all subscribed to the channel? I mean, again, I'm not going to lie to you. You can get mad all you want to. I'm not going to lie to you. Yeah, what you say. I'm just not going to do it. My integrity is more important to me. Rip, salute, Honorable Kevin Sanders. Thank you so much, Yardley, HBK. Yeah, shout out to Packernaut. Hope I said that right. Anthony's supporters are extremely ignorant and emotional. Well, you know, man, people just want to win. They just want to be right. The problem with adults, the reason why I don't like adults, adults don't like to be told that they're wrong. They don't like to be told what they can't do. And I'm just not going to play this game with you. Just because you don't like what I'm saying or you don't like what's being, I don't care. This is the truth. Why are you here? You don't have to listen to me. Go listen to somebody else if you want them to lie to you. I'm not going to do it. Again, I don't like y'all enough to lie to you. If I had a little fat daughter with a big nose like me, I'd be telling her, baby, you're so beautiful and in great shape and you're beautiful. I lie to her because I care about her. And I don't want to hurt her little feelings. Okay? I'll probably get her some Ozempic and get her a little workout plan, maybe get her a nose job somewhere. But I'm a lie to her. I don't want to hurt her little feelings. But you all, I don't like y'all enough to lie to you to spare you. I'm going to tell you the truth. That's what I'm going to tell you. I'm going to tell you the damn truth. I'm not worried about the internet's feelings. Okay? Again, I don't like you all enough to lie to you. If I wanted to save your little feelings, I would lie. I don't care. I don't care about being popular. I don't care about your little money that you give me. I don't care if you subscribe to the channel or not. I'm going to be here. I've been doing 2, 3, 4 hour lives since I had 1,000 subscribers. And before that, you understand me? I'm going to keep saying what I'm saying. Because some of this stuff I'm doing is not for you. It's for the people who will look at it another day in 20 years from now. You understand? This is for posterity. This is for legacy. Somebody type legacy in the chat room. So I'm going to tell you the truth. You can call me a lot of things, but you ain't going to call me lazy and you ain't going to call me a liar. See how that works? Thank you so much, brother. Appreciate you. One-on-one background. I'm not mad at KA getting time. I'm curious to know if the environment matters in this situation, i.e. someone attacking you on the stairs, bleachers, on the roof. So it could matter. It could matter. But, you know, once they released that video, that whole argument that he was afraid that he might fall down. I mean, the brother is clearly nimble. Have y'all seen the video? The dude escaped out the tent, ran down them stairs, and it's raining, so you got a slippery thing, and he took off. I think the jury said, nah, this is not some feeble footed young man who's going to trip and fall over himself. You know, so I don't know, man. I can only tell you that the jury only has to have a rational basis to come to the conclusions that they did, and that's the standard. And that's why I limit my conversations. And this is where integrity comes in. I'm not going to entertain, oh, there's a video from somewhere else that you just haven't seen. I'm not going to play that game with you. I'm going to limit my conversation to what we know the jury saw. And that's the evidence. I'm not going to speculate as to what the aliens dropped in the bread basket. I'm not doing that. I'm not going to play that game with you, you know, to try to make you all feel bad. And I know that's why people get angry, because I don't entertain the outside stuff. I'm going to give it to you straight. Shout out to Sonny D. How are you counseling your son in this situation? Number one, I tell my sons, first, let me explain something, because this is important. So you guys who don't know, my sons have been practicing martial arts for years. Okay. And one thing about practicing martial arts for years, and it's not just practicing, I mean, they literally go full contact and have been going full contact for years as it relates to fighting. You understand what I'm saying? And so because of that, they pretty much know what they can do and what they can't do. They know they can beat people up. They've been fighting and wrestling and grappling with grown men, and they know they pretty much gonna win any encounter that they have. Okay. And so here's the thing: if you pretty much know you can beat people up, there's less of an ego involved when somebody who you know you can beat up challenges you. It's just like it's almost like a chihuahua barking at a dinosaur. It's like, I'm going to ignore you because you're not even worth entertaining. You see, that's how that works. I'm not. And so what people don't realize is that practicing martial arts, boxing, especially when you're forced to do it, it kills that instinct to always try to go out and prove yourself by punching somebody because you know you can win anyway. It's like trying to impress a rich person with a Bentley. They like, I got a $30 million trust fund. I'm not really impressed by your Bentley. You see? And so that's the psychology that I've imposed on my sons just by putting them in these fighting sports. So how do I counsel my son? I pretty much don't have to, because they're conditioned to realize proving themselves in a fist fight is not proving their manhood. They don't get their egos and wrapped up into how many people they can beat up. And so that's one of those things. You know, you involve them in these violent sports, and they know their limits. They know what they could do. They know what they're capable of, and they just don't even want to do it. It's like somebody. I remember I had about 4 cars in the driveway, two in the driveway, 2 in the garage, and I would take Ubers different places just because I didn't. I'm like, but you got all these now. You got a Bentley, a BMW, old school '65 Cadillac with some 20-inch rims. It was crypt blue with the white and the pipe, and it had the drop top. This is around about 2008, 9, 10, whatever. And then I had a cherry red Chevy Impala on some Daytons, and I had the hydraulics. I didn't want to drive nowhere. I just take an Uber. You see what I'm saying? And so you don't have to prove anything when you get to that point. Okay. And so that's kind of where I was. I think I might have a picture of those cars. Let me see if I find it. But in the meanwhile, thank you so much, Sonny D. I appreciate you. Let's move on to the next person. Robert Fall. Thank you, Mr. Spurling. Thank you too. I appreciate you for the super chat, the Cash App, and the paper. Let me see if I got it. Yeah, this is my let me see if y'all can see this. This is I'm gonna put this up. Not that I want to get off subject. But this is my blue Cadillac right there. Look at my little kids, me and my boys. I had a 1965 Cadillac, man, with some 20-inch rims on it. Boy, I would be riding around Houston with the top down, man. And then I also had this that's a 1971 Chevy Impala. And those are Dayton's. You see, I got it pancakes in the yard. Yeah, buddy. You can take him out the hood, but you can't get the hood. That's Roman right there when he's about 2 or 3 years old. So yeah, this, I was riding clean, man. You see, I'm the coolest person y'all know, man. You see that this picture is from, I believe, 2014. Is that from 2014? I think that is 2014. So I'll be riding around the city of Houston in that, man, just chilling out. I used to have a lot of girls in the back hanging out with me, hitting switches, riding up West Time. I used to just ride around the city doing my thing. But anyway, that was a long time ago. But the bottom line is, at a certain point, I just started taking Ubers different places. You know what I'm saying? Like, yeah. And so that's the same effect that I was kind of trying to bring to you. Yeah, I'm the coolest person y'all know. Y'all need to recognize that. That's why dudes be like, yeah, Uncle D is a legend. You know what I'm saying? Y'all never forget that. I've done everything. I had a conversation with somebody today. They're like, man, you got a purple belt. I've done everything that I wanted to do. There's really nothing else. I've lived the life of 3, 4, 5 men. I've done more in my life than most men will ever do in their so far than most men will ever do in their entire lifetime. And that's what you need to understand. I just don't have anything else to prove. I've done it all. I got 6 studio albums with Beans and Cornbread. I got a TV show that I financed myself. You understand what I'm saying? I've traveled all the places. I've had all the cars I wanted to have. I've been with all the beautiful women that I want to be with, whether we talk about actresses and supermodels, all that, man. So, all I have left to do is just focus on my legacy. And that's why I don't really have anything to prove. And that's why I'm free to talk to you all like I do, man. But anyway, thank you so much. And that was kind of further more for Miss Sunny D. Yeah, but other than that, Sunny D, you got to tell them to walk away. It's not worth it. But anyway, let's get back to it. Hennessy Bastion, thanks for trying to inform the community. Thank you so much, brother. I appreciate you. Also, roll the tape. Appreciate your commentary on this case. Willie D does a lot of clickbait and will side with the people regardless of the views click. No, Willie D is speaking on behalf of the large masses of the people. He's speaking very passionately, and that's how people feel. All I'm doing is just pointing out the law. I'm just pointing out what this is. That might be how you feel. That's how the people feel. So he's doing a great job of advocating on behalf of how people feel and what regular people think. It's not his job to tell you what a lawyer would say. That's why he brings me in. And the reason he brings me in, if you get a defense lawyer on there, the defense lawyer is going to come from a defendant standpoint. They're going to make up all kind of stuff and say, yeah, this is possible. That makes you feel good, but it's not accurate. A prosecutor is going to come in there and tell you all the reasons why the guy should go to jail. I'm not going to do that. Okay, I'm just going to come in here and give it to you straight. So, no, Willie D is doing his thing, and I appreciate the brother for having me on. I remember, man, let me tell y'all something. My dad used to have an office down at 1600 Smith. This is downtown. It's a tall, white building downtown Houston. And I remember I was probably about 18 or 19 years old. Probably, no, let me see. It had to be, I was about 18 or 19. I had to be at least 18. Willie D was one of my dad's clients. Willie D came in, and I remember him telling me, yeah, Willie D from the Ghetto Boys. I'm like, what? So I'm sitting there looking. I looked over my shoulder, and it was Willie D. He had a hat on, and he came in and he did a consultation with my dad. I asked him about it. I said, what did he need? He said it was just a little consultation. I think it was about some entertainment stuff or some music stuff. But I remember that was the first time I remember seeing Willie D. So I've been knowing Willie D for, hell, I'm 52 now. Hell, that was 34 years ago. That was the first time I saw him. And yeah, that's crazy, man. Small world. So, and I know Willie probably don't remember, but he might remember going down to that office. 1600 Smith was a tall building downtown. So, anyway, let's move on to the next subject. But shout out to Willie D. Thank you, Roland Tate, for bringing that up. No, but Willie D is doing a great job advocating and speaking on behalf of regular people. And it's good to go on there. And again, like I said, he brings me on there because I don't have a dog in the hunt. I'm going to explain to you exactly what it is. And you see how I break stuff down because I'm really a good teacher. And that's why I really have so many followers, because I break the stuff down for you all. Shout out to World Trade Traveler 70 became YouTube member. Good looking out. Welcome to thank you to the membership. Joey Camel, thanks. I'm leaving a lot. Thank you so much. I appreciate you. Do you agree with attorneys' press conference? How big of a gamble is it to have these, in your opinion? Attorneys, Anthony's press conference. Yeah, I believe in being quiet. I have a case now out of Missouri. It was actually just sent over to Illinois, where a young lady, a young member of Alpha Kappa Alpha, her name is Lamori Moore, and she pledged Alpha Kappa Alpha back in 2019. And she went through a hazing process that involved members of Alpha Phi Alpha. This is all in the complaint, federal court. And she alleged that she had to go through a lot of traumatic experiences while she was being pledged by Alpha Kappa Alpha and Alpha Phi. Keep in mind, I'm a member of Alpha Phi Alpha. Okay, I'm a ice cold brother of Alpha Phi Alpha. So I end up suing Alpha Phi Alpha and Alpha Kappa Alpha because Miss Lamori Moore eventually died by she unalived herself in her mother's basement. She hung herself in her mother's basement. And so her mother contacted me about a year ago. Statute of limitations was an issue, but I ended up filing in Missouri, and we've been fighting this case for about a year. And several people, including fraternities and sororities, or some sororities, have approached her. A Hispanic, a Latino sorority has asked me to come speak, and they asked her to come speak about hazing and the issues that her daughter had to deal with in Alpha Kappa Alpha. And I said, no, we're not going to talk. We're not going to say anything. We're going to remain silent, because anything that you say is discoverable. Defense attorneys can use it. They'll use it against you. And so we're not going to do that. So this is probably only the second time I've spoke about this, but the case is Lamori Moore versus Alpha Kappa Alpha. It was in St. Louis, Missouri, and it just got transferred to Illinois. It's a tough case, and I get a lot of tough cases, but I think this young lady's life is worth fighting for. And so that's why I took the case. It's a horrible situation, but I don't really believe in press conferences. That's not what I do. I don't believe in press conferences. And, I tell my clients, we don't do them over here. Okay. We don't like to do them, but if you guys want to check the case out, you can kind of follow the link. Here it is right here. It's, I don't know if you guys can see this, but I'll see if I can pull it up real quick for you since we're on it. Not that I want to get sidetracked, but let me see here. But this is what plaintiff personal injury lawyers do. A lot of y'all think, oh, we just, over here chasing ambulances. Somebody type chasing ambulances, but I really put it all on the line for my clients. I go all out. I don't hold back. When I get involved in something, like I said, there's two things I'm not. I'm not a liar, and I'm not lazy. You understand what I'm saying? I'm not a liar, and I'm not lazy. If you hire me, you're gonna get the best service that we can give. See, and then I'll put, I'm actually lead counsel on this particular case, but I will put whoever I need to put to do what we have to do to make sure the client gets justice, and that's kind of the most important thing to me. But and it's unfortunate that this young lady passed away, but we're doing the best we can to try to get justice for her mama, and her dad, who have to live with the fact that their daughter, and we're alleging that she died by self-inflicted unalivement because of the trauma and the stress associated with hazing. Now, again, it's a tough situation, but again, here's the case right here. Estate of Lamori Moore et al. Versus Alpha Kappa Alpha sorority. And this is all the people that, in this proceeding before this judge. Again, like I said, it was just transferred over. But I mean, since December 12, 2025, look at all these filings. You see? This is what I'm doing last year while I'm talking to y'all, screaming at the internet. Y'all out there calling me a fake lawyer, and this is all the groundbreaking work I'm doing. Look at that. You see that? Lead attorney right there, Dennis Spurling. You see? This is me filing this lawsuit. But and this is a little bit more about the case. Gave you the docket number. But anyway, yeah, I don't believe in press conference. I believe in silent wars. Okay, somebody type silent wars in the chat room. We do all our talking in the courtroom. All right. If it comes down to it, we don't need to talk anymore. We can deal with it in the courtroom. And you open yourself up for defamation suits if you happen to say something you shouldn't say. You got to be real careful. Matter of fact, I've sued a couple of people on the internet for saying stuff like that. You call me a fake lawyer, you're gonna catch a lawsuit. That's what I do. I don't play these games. I don't mind people critiquing my conversations and my take on things, but you're not going to talk about me personally without catching that lawsuit. You're going to catch that legal fade. Somebody type run the fade in the chat room. Anyway, Black saying they tried to kill me is all he needed to say. Man, right? Okay, Black saying intelligence. Shout out to Black saying. Remember when the young man said, it's not alleged it was me, or he put his hands on me. Had he said something like they jumped me or they tried to kill me, or they were trying to push me over the banister, right? That would have also been admitted. That would have showed his mindset. You understand what I'm saying? Now I'm gonna tell you to shut up. Any good defense attorney is gonna tell you shut your mouth. I remember my dad. Funniest thing, and look, I get all these stories. My dad told me, I said, Dad, do you ever ask your clients what happened in the case? And he said, no. I'm like, really? Criminal defense. He said, no, I don't ask them. I'm like, you don't ask your client what happens in the case? He said, no, I go and I tell them to hold on. What you charged with? This is what you charged with. I go down to the courthouse. I look at the district attorney's file. I see what evidence they have. I come back and tell my client what evidence the district attorneys have. And then I say, what do you say about this? What do you say about that? What do you say about that? Literally, he does not want his clients to tell them whether they did it or not. Okay. He just wants to tell them this is what the DA said you have. And what is your response to that? You understand what I'm saying? So he doesn't want, so yeah, shut up. If you ever get pulled over by the police, the best thing to say when you get even when you get pulled over on a traffic stop, you know why I pulled you over? No, first of all, have your insurance and your driver's license and hanging out the window with all the windows there, hand on the steering wheel. And then when the officer comes up and asks you, do you know why I stopped you? No, officer, I don't know why you pulled me over, but I'm sure you have your reasons. I'm going to defer to your judgment or assessment. That's what you do. And now there's nothing else for them to talk about. Do you want to speculate? No, officer, I'm sure you have your reasons why you pulled me over. I would only be speculating or guessing. I don't know. Okay, now if you got dope and a gun in the car and they've been tailing you for 15 miles, they already got you. You just need to shut up and lawyer up, get out the car, let them put you in handcuffs, don't resist, hop in the back and take that ride, but just shut up. Had Karmelo Anthony just shut up. And for all you people who keep saying stuff like, oh, well, he could have testified, you already got somebody who admitted he did it without being asked. Do you really want to put this boy on the stand? Do you think it's a good idea to put him on the stand? He'd already admitted he did it. All they're going to say, well, on this day, you said you did it. You never said anything about they jumped you. How could that be helpful? In what circumstance would him putting him on the stands be helpful to his case? He'd end up getting 99 years if they let that boy testify. And you all are trying to sit here and second guess what his lawyer did. I'm saying his lawyer is a former prosecutor, just like Johnny Cochran. Remember that? They know the tricks. You understand? I'm just pointing that out. But anyway, yeah, they tried to kill me is all he needed to say. That would have been very helpful. That would have been some evidence that came in. Shout out to you. Thank you, Terrell Steppers. He said 199. Thank you so much. Ivante, the best presentation I've heard on this case. Genius. Thank you so much, family. Also, weak and wimpy. So were the actual jurors in the educational field or not? Well, I'm assuming they were. And those race neutral reasons was why the prosecution said that they wanted to get them out of there. Maybe they would be too sympathetic to one side. They couldn't be impartial. They were too impersonally involved. So, for whatever reason, if there were other lawyers out there who weren't, if there were other jurors out there who were educators, that's going to kind of eliminate their ability to just say that that's race neutral. It looks pretextual. In other words, it looks fake. So, and that's something for the dream team of lawyers to determine, right? We'll just have to see. Let me see here. 99 Problems 253 says, If I missed it, I apologize, but can you explain at what point premeditation can be established? Yeah, this wasn't premeditation. Okay, here's premeditation. You get in a fight with somebody in the bar, okay, and then you decide to go to your car, get your glove compartment open or pop the trunk and come back blasting. That's premeditated murder. That's capital murder, okay? Or you plan to, you decide you're gonna go rob somebody and kill them. That's capital murder also. But premeditated means, you didn't have a time. You actually went back and you could have escaped, but you didn't. You came back blasting. So that's a quick, simple answer to kind of explain that. Also, Black saying 6368, teenagers misspeak all the time, not an adult. Well, you know what? They do misspeak all the time, and so do drunk people, but they still hold that against them, don't they? It's what it is, right? They just, I'm saying, yeah. And also, he could have been misspeaking on the stand, and the jury would have took it as what it was. Let's see what else. Big J773 said there was a woman in the original report that said that Metcalf fell on the knife. Do you know how much force you have to use to stab someone through the sternum? A lot of these, a lot, they purposely set them up. So he didn't stab him through the sternum. See, that's the thing. He didn't stab him through the sternum. It went, and let me go into some detail. It went into the and I read this earlier. Okay, it was basically it went straight into the left ventricle of the heart. So it didn't get stabbed. He didn't get stabbed through the sternum. So that's stab. The sternum is this bone in the middle of the chest. That's not where it went. Okay, it went through the rib cage, sideways, right into the heart. Okay, so but see, the thing is, here's the problem, Big J. Okay, here's the problem. So that's exactly why we have to separate internet claims from trial evidence. So if somebody in an original report said something about a knife, a stolen knife, the question is whether that actually came into evidence at trial, whether the witness testified to it, whether it was objected to, whether the jury was allowed to consider it. And when you say stuff like how much force does it take, point that actually, that actually cuts against the defense in some ways. If the wound went deep enough to reach the heart, the state is going to argue that that wasn't some accidental touch. They're going to argue that it was a deliberate use of deadly force. But I wouldn't say through the sternum unless the medical examiner actually testified that a knife went through the sternum. A chest wound and a heart wound are not automatically the same thing as is going through the sternum. That exact path matters. Okay. And so my answer is simple. If it wasn't in the trial record, it doesn't matter for the direct appeal. And that's where we are now. If it was in the record, then the appellate lawyers can use it. But we can't build an appeal on rumors and internet posts or what somebody said was in the original report. And the Fifth Court of Appeal is going to look at the record and not the comments section. See, that's the thing you got to understand. And see, this is why we here separating internet rumor from the actual facts. But thank you so much. Also, Malik Liker says, does Texas have pre-sentence investigation? Karmelo got sentenced quick as hell. That ain't ordinary. No, man. The jury sentenced him. The jury had a range 5 years to 99 years. They did the conviction phase, and then they turned right back around and did the penalty phase. The jury, not the judge. You know how they have those famous cases where you can sit up there and the judge reads. You said the jury convicted him, and the jury sentenced him, and that's why it went so quick. Those people wanted to go home. So yeah, it did go quick as hell. But anyway, Austin told Karmelo, "I'm not going to fight you." Yeah, okay. Austin told Karmelo, "I'm not going to fight him," right? But Austin then turned around and pushed Karmelo. So you said you're not going to fight him, but you did push him. To me, it's a push fight. Okay, you still put hands on him. Now, again, I'm not speaking disparagingly of Austin Metcalf, because whatever you think he did, and he should be punished for. That young man paid the ultimate price. You understand what I'm saying? He's already paid the ultimate price. Okay? He got the death sentence for pushing Karmelo Anthony. Okay? But you can say he said, I'm not going to fight you, but then he pushed him. So that seems like a conflict, right? Right? That's like somebody said, I'm not going to steal your car, and then they break your window and then hop in your car and turn the engine on, about to drive away. Right? Is that accurate? Hmm? Hmm? Huh? Absolutely not. So, you can say I'm not going to fight you and then push somebody. Obviously, what you said was inaccurate because now you're pushing leads to fights. So, does that make sense? I don't know why people keep saying, well, he said he's not going to fight. You pushed him. That's how you start a fight. Even if you said you're not going to fight him out here on the track meet, you pushed him. And I think we all can agree on that. But anyway, let's move on. Thank you so much, Greg. If you were the defense attorney, how do you prove doubt after he confessed his doubt? You can't prove doubt. That's what I'm trying to tell you. This is the whole point. Where's the reasonable doubt? There is none. Your best shot is try to raise a self-defense argument. But how do you raise a self-defense argument if your witness if you don't want your witness to take the stand? Right? Think about that. Your witness won't take the stand. How do you prove a self-defense argument? Well, you can infer this by that, and this way he admitted he did it. It's the young man was going to jail, family. Now, at this point, we're dealing with the appeal, and you can second guess this, but a dead body, a murder weapon, dozens of witnesses, and a confession. You are going to go to prison. And however distasteful you all find this, it's unfortunate because he seemed to be a young man with no criminal record. You don't really get around that, period. Shout out to Black saying, Clemency, who is the governor here? Shit. Clemency. Do you know who our governor is? Do you think our governor? Do you know who I got? Greg Abbott? Greg? Hell no. No, that's not gonna happen. Not here in not in Texas. This is the same man who busts illegal aliens all across the country to prove a point. I'm just saying, whether you agree with it or not, it won't be any clemency. No, he ain't gonna do it. There's not gonna be any clemency in this case. But anyway, you guys make sure if you haven't subscribed to the channel, you do that. I'd appreciate you all do that. Did I answer all the questions? Did y'all learn something today? Did you all learn something? Did you all learn something? I'm just happy to know you learned something. I'm happy to know you learned something from your Uncle Boule, Uncle House Negro, somebody type Uncle Ruckus in the chat. That's what y'all been calling me because I'm telling y'all the truth. I don't give a damn. I don't care if you like it or not. You gonna learn. Y'all not gonna be out there making me look foolish and wasting y'all time telling people he's gonna get it. He's not. You understand? Somebody, let's see here. We got let me see here. We got another question. Doesn't context matters as to why he stabbed him, regardless if he admitted it? Now, I went over that earlier. Okay. And I went into some detail and I explained this. And I explained to people that, intent can be inferred by conduct. Okay. And I use the analogy where, you didn't intend to get your side chick pregnant, but you did sleep with her. Okay. And so even if you didn't intend to get the girl pregnant, your context. So let me say, context matters. Okay. Of course, context matters, but context is not a magic eraser. Context, it may explain why he stabbed him, but it doesn't automatically make that stabbing legal. And that's the point people keep missing. The law doesn't stop at why did he do it. The law asks, was deadly force legally justified at that time period, at that moment? And that's a much harder question. So yes, the jury could consider the intent, the argument, who touched who first, who was bigger, whether Karmelo felt threatened, whether he was surrounded, and whether Austin put hands on him. All of that is context. But after looking at the context, the jury still had the question, did Karmelo reasonably believe a knife to the chest was immediately necessary to stop Austin from using deadly force or causing him serious bodily injury? And the jury said no. See, and that's why the admission matters. Once he admitted the stabbing, the case moved from who did it to was it justified? And if the jury didn't believe deadly force was necessary, then the context doesn't save him. Okay? Context can reduce a case. Context can explain the case. Context can support self-defense. Context can support manslaughter, but context doesn't automatically equal acquittal. And so, yes, context matters, but the jury heard the context and still convicted Karmelo Anthony of murder on appeal. The question is not whether someone online thinks the context should have mattered more. The question is whether a rational jury, I want you to hear this standard, whether a rational jury could hear that same context and still reject self-defense. And based on the reported evidence, yes, they could, and yes, they did. Does that answer your question? I hope that answers your question. I hope that answers your question, right? And somebody is saying, well, y'all got some more questions. Y'all got a lot of questions. All right, I guess I'll keep answering as long as y'all keep coming with the super chats. I'll keep answering your questions. So putting your hand in your bag to grab a knife after saying, touch me and see what happens. This brother is asking why that's not premeditated, or saying what isn't that premeditated? Again, so premeditated traditionally, and I use this, you get in a bar fight, you go back to the car, you get your gun. Okay, you come back and shoot. Okay, that's easy to understand. But premeditation is not the word I'd use, because Texas murder law doesn't require premeditation the way people use the word in everyday conversation. The better word is intent. Okay, and if the evidence showed that Karmelo said, touch me and see what happens, then reached into his bag and grabbed a knife and stabbed Austin in the chest, the state can absolutely argue that shows intent. They can argue that wasn't panic. They can argue that wasn't an accident. They can argue that was a warning followed by an action. But legally, they don't have to prove he planned it for 5 minutes, 5 hours, or 5 days. Intent can form in seconds. Murder can happen in seconds. So yes, that fact pattern is bad for the defense, brother. It's very bad. But the legal issue isn't premeditation. The issue is whether a rational jury could infer that he intentionally or knowingly caused death or intended serious bodily injury and committed an act clearly dangerous to human life. And if the jury believed that he said that, reached for his knife and stabbed Austin in the chest, then yes, a rational jury could absolutely find intent. And that's why I keep saying legal sufficiency is not strong on appeal. But what this really means is, let's say they mess around and do get a new trial. Okay, let's say they do get a new trial. What's to stop the new district attorney from adding capital murder on top of murder and manslaughter? So now, not only now are you dealing with possible murder and life sentence, they might throw capital murder in there. You understand what I'm saying? So, and I'm going to kind of talk about this a little bit more in my closing statement, but it's a dangerous game that they're playing. So that's very observant of you, but they didn't overcharge him. They didn't treat this as a traditional premeditated murder where you get in a bar fight, go back to your car, get a gun, come back out and pop somebody. They basically saying it happened so quick, it was just a continuous thing and they didn't treat it like premeditated. But yeah, they theoretically they can do that. So again, somebody type dangerous game in the chat room. Somebody type dangerous game in the chat room. It's a dangerous game that you're playing. We're not talking about appeal in a car accident or a class action. We're talking about appeal in a murder conviction where you got a real body, and you never know. It's a dangerous game, and you got a lot of people on the internet gassing people up and putting batteries in their back saying you should do this, you should do that, and you got this dream team of lawyers. I guess we'll see. But let me just wrap this thing up, man, because at the beginning I asked y'all a simple question. Do you want the truth? Well, you all stuck around. There's been about 800 of y'all in here. Huh? So here it is. There it was. I'm not here to lie to you. I'm not here to make you feel better. I'm not here to sell you hope. I don't have a dog in this hunt, as I've explained in very detail. I practice complex civil litigation, personal injury cases, so I don't care one way or the other. I'm not a defense lawyer or a prosecutor, and that's why I can give it to you straight. So I'm not going to lie to you. I'm not trying to represent Karmelo. I'm not trying to do any criminal defense. I'm not doing any of that. I did a little bit of that with my dad. I didn't like it then. I don't like it now. I'm not a prosecutor. I'm not running for district attorney. I'm not running for judge. I'm not running for any political office. So I don't have to shade this thing. I don't have to spin it. I don't have to tell one side what it wants to hear. I can tell you the truth. And the truth is, this appeal is going to be extremely hard. It's not impossible, but it's going to be hard. Was the evidence legally sufficient? Probably so. So trying to prove it was insufficient is going to be hard. Batson is going to be hard. The jury charge error, if it exists, is going to be hard. It's going to depend on the record. Ineffective assistance of counsel, that's probably not going to fly either. And a new trial isn't freedom. That doesn't mean he's going to get out of jail. Parole eligibility isn't release. Just because you come up for parole, that doesn't mean they can let you go. So he might say he's eligible for parole after 17 years. In the 35-year sentence that he received, that's a long time. But it's still within the Texas punishment range for murder, which is 5 to 99 years. That's the truth. Does that make me a sellout for telling y'all that? See, some people can't handle that. Some people can't. You just can't. You can't. But I'm not going to change the analysis just because the truth makes people uncomfortable. I'm not going to lie to black people to make black people feel better. I'm not going to pretend bad facts are good facts. I'm not going to pretend a weak appellate issue or strong appellate issues. I'm not going to pretend the law works a certain way just because people online want it to work that way. That's not what I'm going to do. You wanted the truth. You came to this page. I gave you the truth. And if you can handle it, you can handle it. If you can't, that's on you. But see, this is what I do here. I give you the cold, hard truth, the legal truth, whether we're talking about history, whether we're talking about society, whatever it is. And whether it feels good or not, it's the truth. That's what I owe to you. Even if Karmelo Anthony wins something on appeal, that doesn't automatically mean he walks out of prison, family. It doesn't automatically mean he gets an acquittal. And it doesn't mean he gets a release. In most cases, if a conviction is reversed because of a trial error, the remedy is a new trial. Somebody type new trial. That means the state gets to try the case again. And that's dangerous. Somebody type dangerous in the chat room. See, y'all hear new trial and start celebrating like the case is over. No, A new trial means the whole fight starts over. The state still has a dead body. They still have a murder weapon. They still have the medical examiner's testimony. They still have witnesses, dozens of witnesses, eyewitnesses, and they still have Karmelo's own statement where he admitted that he did it. And because most of those witnesses are young, they still going to be alive and available and ready to testify if the case gets tried again in a few years. So a new trial isn't some automatic good news. It's new. It's a new opportunity, but it's also a new risk. They can upcharge that boy. And now he's looking at capital murder along with murder and a lesser included charge of manslaughter. They can argue that same scenario that the young brother brought up where he said, I'm going to do it if you do this. That's premeditated. They could argue that. It is what it is. You can't control what the prosecutor does. But, you know, for you guys who've been here for a long time, this is why they call me the bad guy. I tell you all, I embrace being the bad guy over here. I'm the bad guy on YouTube. There's some people that know better than to even say my name. You say my name and you say something wrong, you might get sued. You might get your channel demonetized. You understand what I'm saying? And I'm not going to talk about it. Somebody type silent wars in the chat room. I fight quiet. But they've been calling me the bad guy for 6 years. All the time I've been here on YouTube. Largely because I tell the truth and largely because I don't hold back. I tell the truth when we're talking about degenerate behavior in the Black community. I tell the truth when we're talking about bad decisions and broken families and weak leadership and emotional thinking and people making excuses for behavior that's destroying us from the inside. I tell the truth when it's uncomfortable. I tell the truth when it makes people angry. I tell the truth when people would rather be lied to. And I also tell the truth about racism and how racism exists and it's real and it's not going anywhere. And so instead of pretending America is about to become, you know, some fair because we cried hard enough, my position has always been simple. Understand unfairness exists, whether it's in the form of racism, sexism, whatever. Study it, navigate it, and stop making emotional decisions in the country that has never rewarded Black people for being naive. And yes, I tell Black people to vote their interests, even if that means voting Trump or Republican or not voting at all. Vote your interests, not your feelings. There's no such thing as party loyalty. You vote your interests, not what celebrities tell you to do, not what the church tells you to do, not what the internet tries to shame you into doing. You vote your interests. Again, even if that means voting for Donald Trump. Vote your interests. You may not like him personally, but some of his immigration policies may have served Black American interests, just like every other American. I just say it. See, that's the conversation grown people should be able to have without y'all calling names. But people don't want grown conversations. They want comfort. They want applause. They want slogans. They want somebody to tell them everything is racism when it's convenient and nothing is personal responsibility when accountability shows up. And that's not what I do over here. So yes, people get mad at me. People call me names. People call me sellout. People say I'm against Black people. At least that's what you're saying this week. People say I'm too hard. I heard somebody out there saying I'm Mexican. Somebody shout out to all the Mexicans. I ain't never met a Mexican with a middle name Damon. You know my middle name is Damon. Y'all know any Mexicans named Dennis Spurling? And it's just people just silly enough to believe that because they want to be mad at me. He light-skinned. His mama white. My mama name is Gloria Jean. She's from Mississippi. She is not white. Okay? But, you know, they're angry because they say I'm too hard. They say I don't care. But none of that matters to me because it's more important for me to tell the truth than to be liked. I'm one of those type of people. I don't need you to like me. And it should be refreshing. Because, see, it's oftentimes that person that doesn't like you who ends up being the most honest with you because they're not trying to spare your feelings. It's that drill sergeant that didn't like you that made you better and made sure you survived that war zone. It's that basketball coach that made you improve yourself. It's the volleyball coach. It's that school teacher. You see? I'm just saying. Y'all know I'm telling the truth. That's the person you remember, that chemistry teacher from the 8th grade. It's the one that helped you get that high score on the SAT. I'm not here to cater to your feelings. Let me tell y'all something else. The reason I have over 100,000 subscribers is not because I had some big viral video. It's not because I had some superstar guests. It's not because I had gimmicks or stunts or flashy production. I built this by telling the cold hard truth. No frills, no games, no hand holding, no emotional babysitting. Even that whole fight that I had with the internet for about 2.5 weeks when they were trying to disparage Kevin Samuel's name is because I stood up and told the truth when people were lying on that man and his body wasn't even cold in the ground. People didn't come here because they thought I was going to be the next Kevin Samuels. Clearly, I'm not. I don't even talk about relationships. I don't even care what you do. Date who the hell you want to date. They came over here because I was giving the truth when everybody else was making up lies, trying to get clicks and likes. People come here because they know I'm going to say what other people are scared to say. I am not afraid. I'm courageous. That's why I show you all my face. I show you my family. You can Google me. You can look me up. You can't compare me to the people who hide their images and faces from you. They're not like me. They have something to hide, and that's why they do. But how can you be a truth teller if we don't even know your identity? But I'm going to continue telling the truth. That's what I do. And if it hurts your feelings, if it makes you angry, even if it makes you call me mean names, even if it makes you unsubscribe, even if it makes you run to another page where somebody will lie to you for likes, go ahead. Because a person who truly respects you, somebody type respect, a person who truly respects you will tell you the truth to your face. Ladies, wouldn't you prefer men to tell the truth to you instead of lying to you? I'm just saying, fellas, wouldn't you prefer a woman who you intimate with to tell you the truth? I'm just saying. We have a very unique relationship. I come into your homes and your cell phones and I talk to you guys every night and you trust me. You trust that the information that I give you is truthful. I don't want you to take information out that is not true because that makes you look bad. I'm not going to just try to keep you comfortable. Again, people who truly respect you will tell you the truth to your face. A person who doesn't respect you will lie to you just to keep you comfortable. And that's the difference. I'm not here to comfort you. I'm not going to waste your time or your money. So you make your own decision. And see, this is the same thing I do in the practice of law as a lawyer. I'm one of those lawyers who's bluntly honest. And that's very rare. If you have a bad case, I'm going to tell you up front, it's a bad case. But I'm also tell you, that's all I get is bad cases. You understand? But I still make the insurance companies pay. I still make the trucking companies pay. See, the good cases, the easy cases, they go to those lawyers that scream on commercials or tell you how they have offices, law offices all across America. That's where the easy cases go. I have an intimate law practice. At any given time, I have about 40 to 50 cases open. So I know each and every one of my clients. I'm intimately associated with the facts of their case. That's why I'm able to do so well. That's why I'm able to have the success record. You don't practice law for 26 years in this field and not be excellent at what you do. And just like in my practice of law, I respect you enough to tell you the truth. That's integrity. And that's who I am. And that's why whether you like me or not, you keep coming back. Somebody type, come on back in the chat room. See, deep down inside, you know I'm not here to sell you a fantasy. See, I'm here to give you that hard truth, that cold truth, that legal truth. And if you can handle it, you're welcome to the page. And if you can't, that's fine too. Now, I'll say this. Somebody put my phone number up. You all are hilarious. Yeah, that's funny. Yeah, that's my office number. Some of y'all, he's a fake lawyer. You can call my office right now. Tell them you're a new client, wherever you are. You'll see how fake I'm real. But I'm going to say this before I go out of here. One mistake that I will say, because I don't really want to talk about Karmelo Anthony's trial too much. I think one of the biggest mistakes Karmelo Anthony and his family made was not hiring a black lawyer from the beginning. And I'm not saying that because a white lawyer can't be competent. That's not what I'm saying. I'm saying that because black lawyers often have more experience dealing with black clients. Just like black doctors have more experience dealing with black patients. You see? Black lawyers have more experience dealing with black clients and white juries and racial assumptions. The way young black defendants are viewed in courtrooms, they understand that. And that matters. It matters when you're dealing with all white jury or a non-black jury. It matters when your client is a young black man accused of such a heinous crime as killing a white teenager. It matters when the whole case is sitting inside a racial context, whether people want to admit it or not. Because let's be honest, shout out to my man Fuquan. When some people see a young black person, especially man, accused of something, they still think the worst. They're not going to say it out loud, but the assumption is there. The stereotype is there. The fear is there. And the bias is there. The suspicion is there. And if you don't understand that reality at a deep level, how can you fully defend against that? A black lawyer is going to understand something that a white lawyer wouldn't understand because he has those lived experiences. And see, that's why representation matters. Not just legal representation, but cultural representation. A black lawyer who has tried cases in front of all white juries, and I'm not just talking about any black lawyer, because you also got to consider the fact that a person from Haiti or Nigeria or Ghana or wherever, even though they may be black, they may not be black American, or as they say, foundational black American, or Solon people, or what we used to call African American. So they wouldn't understand either. I'm talking about if you're a black American client and you have these serious charges, even in my cases, when you're dealing with people who've injured, I understand black pain. There's a study saying that even the medical providers disregard black pain, back injury. That's why we not all out there strung out on drugs like a lot of these people who were prescribed pain pills 10, 15 years ago. They wouldn't prescribe black people pain pills because they said we didn't feel pain like white folk. Isn't that crazy? Woo-wee. But it saved us it saved us a second crack epidemic. But the bottom line is a black lawyer has tried cases in front of white juries who has defended black clients in these hostile racial environments and who understands how race moves in a courtroom without anybody saying the word race. Shout out to my man Fuquan. And it brings something different to the table. Look at that brother in South Carolina, Sean Kent. Somebody type Sean Kent. He's the one that defended Rick Child. I'm absolutely certain that black man has handled worse case with worse fact and harder clients in tougher circumstances than Rick Child. He practices in South Carolina, one of the most racially loaded states in America, in the original Confederate South. Sean Kent knows what it means to defend people, black people in that environment. He knows what a white jury may think. He knows what a state may try. He knows how to talk in the courtroom and the racial undertones and the dog whistle. And that's the difference between having black lawyers like Johnny Cochran, like my father, Dennis F. Spurling, like Mr. Whitcliffe, who I mentioned earlier, and all those other black lawyers who came before us. They didn't just know the law, they knew the system. And they knew racism, they knew juries, they knew stereotypes and perceptions that they have. They knew how black defendants were seen before they ever opened their mouths. And to me, that was one of the biggest mistakes in the Karmelo Anthony case from the beginning. Anybody who understood the racial dynamics of this case could have told you that. You had to ask the right people. But I'll tell you this too. If y'all keep calling every black lawyer a sellout or boule or a house Negro, don't be surprised if black lawyers don't want to deal with you. Every time a black lawyer tells you the truth, like myself, you call him boule, you call him a sellout, you call him a coon, you call him anti-black. Then don't act shocked when black lawyers decide it's not worth talking to y'all on the internet at night. You understand what I'm saying? Every time you don't get the outcome you wanted, you start screaming ineffective assistance of counsel. Don't be surprised when serious lawyers look at the situation and say, no, I'm good. I'm good. No. Because see, I can speak for a lot of black lawyers, not all, when I say this. We are often overlooked by our own people. You'll get a white lawyer, you get a Jewish lawyer, but you overlook black lawyers. We're ignored until there's a crisis. You see who he decided to get on his appeal, right? I'm just saying. See, we're ignored until there's a crisis. See, when the white lawyers fail you, take your money, and then you want to come to us. We're disrespected until there's a problem. We're called sellouts when we tell the truth. Or you ain't fight hard enough for me. You got a body and 3 priors and 4 witnesses snitching on you, and it's our fault. But see, then when things go bad, people want to know, well, where were the black lawyers at? Well, maybe the black lawyers were right the whole time. Y'all just didn't value us until it was too late. So, take that with you. Other than that, this is Uncle D. God bless y'all. As always said this time, I'm out.
Dennis Spurling Podcast. Hit the like button, subscribe.